there is another bench, I suppose. 3, 4, there is a Asana bench. It's a matter pertaining to three.
Matter pertaining to revenue registration.
No, there is a senior bench.
Code 5.
Code 5. Code 4. Code 5. You will have to mention there. Any mention for listing before the appropriate court. Review and all those I can take up.
Lordship, it is best 3 matter after all.
I am not the appropriate. There is a senior bench.
Code number 5.
Please rush.
Maybe, Lordship. With due permission of the others, Lordship, I beg to mention item number 10, Lordship.
Mention memo was good. Okay. Adjourn. On the prayer of the learned counsel for the petitioner. Registry, the matter stands adjourned. Registry to list this matter after 4 weeks on a date to be fixed by it.
May I play Lordship? Lordship, bring for listing of an IA tomorrow, Lordship. Lordship, the main matter has been listed before your Lordship's bench.
Tomorrow. Then fine.
Somehow IA got listed. Problem.
My lord, I'm praying for listing of a review petition on the day after tomorrow. Your lordship was pleased to fix it today, but it has not come.
Anani. Oh, it was Wednesday, Thursday. Fine.
Much obliged.
Yes, Lordship, I beg to mention for item number 17, Lordship, praying for seeking an adjournment on behalf of Mr. UK Goswami,
17.
correspondent.
Why? Ground?
On because of personal difficulties, Lordship.
Have you taken the consent of Mr. Muzumdar?
Yes.
On the prayer of the learned counsel for the respondent, Mr. Pray on behalf of the respondent, Mr. UK Goswami, CGC, and not objected to by the learned counsel for the petitioner. Registry to list this matters again after 4 weeks on a date to be fixed by it. So we are proceeding for final disposal.
Lordship has already had it at length.
Forgot.
Okay, Lordship.
Just a brief introduction will do.
I am handing over your Lordship brief note on submission, your Lordship. I have prepared. Your Lordship, on 30/10/2009, your Lordship, while the petitioner was posted at Dumduma branch, your Lordship, an order of suspension was suspended, your Lordship. And NPCL, Lordship, is the withdrawal of money from customer accounts by forging their signature. The said order further contemplated to initiate disciplinary proceedings. Then, your Lordship, he was on 25/10, it was revoked, your Lordship, in 25/10/2011, and he was reinstated in
Dumduma branch itself.
Lordship. No, he was in Sanglang branch. Your Lordship.
No. When he was reinstated in Dumduma.
Duma branch, and then, your Lordship, he was transferred to Changlang branch, your Lordship, on 5/11. Then, your Lordship, on 13/1/2022/12, your Lordship, he was written explanation was sought from him, your Lordship. And he replied to it on 30/1/2012. Then on 18/4/2012, your Lordship,
Reply.
he sought certain documents from the authorities, your Lordship. And then those were not furnished. And then, your Lordship, charge sheet was submitted on 18/7/2012, your Lordship.
Just
That is at page 42/43, your Lordship.
31, he submitted his reply.
Reply.
Then 18/4, he asked for certain documents.
He asked for certain documents, your Lordship. Thereafter, your Lordship, charge memo was issued, your Lordship, on 18/7/2012, 2012, and he replied to it on 10/8/2012. There are altogether 5 charges, your Lordship. Now, your Lordship, initially, your Lordship, after his reply, your Lordship, departmental inquiry was processed, your Lordship, and your Lordship will find that departmental proceeding, your Lordship, if your Lordship comes to page 81, your lordship.
I'm there,
82, your lordship.
82 onwards.
82, your
Mm.
lordship. Then, your lordship, while proceeding initiated and started, your lordship,
Hmm.
it was abandoned, your lordship,
Hmm.
in the midway.
Hmm.
And then your lordship will get at page 85.
That was, page 82 is just a preliminary hearing.
Lordship, preliminary hearing, then fresh Stokoe
Suppose
judgment.
also. Hmm. What is the difference between the two?
No, your lordship, except a particular date, your lordship is different, rest are same.
Same, okay.
And your lordship will kindly come to last allegation, allegation 5, your lordship.
Hmm.
The above 4 allegations are only illustrative and not exhaustive. By your above act of commission of the commission and the confidence trust of the people which they had with bank has been badly shaken, and you are directly responsible also which the bank will incur, your lordship.
Hmm.
Till 2012, your lordship,
Hmm.
the allegation of committing these omissions and commission is dated way back to 2009, your lordship.
Hmm.
And till 2012, your lordship, they have not quantified the loss. That means, your lordship,
Hmm.
it will incur 2012.
So this charge was there in 18-7 also.
Lordship.
Okay. What
Now
was the
your
date that was changed?
Lordship, pardon.
Date that was changed. Allegation number 1,
Lordship, allegation number 1, date of-
2008 to 2009. Okay.
That is the only thing.
Then,
Then your lordship, departmental inquiry proceeded, your
hmm.
lordship. Now, your lordship will find from page 87,
Hmm.
certain documents were produced.
Hmm.
Then, your lordship, ultimately, your lordship, a inquiry officer submitted his report, your lordship.
Okay.
And that report, your lordship, exonerated me, your lordship. If record will reveal that, your lordship.
Hmm.
And then your lordship will find that page 95, your lordship,
That first report is not on record.
not on that. That has never been provided to me, your lordship, although they should have, your lordship. Your lordship will find the
Hmm.
further inquiry, your lordship.
Hmm.
Now, further inquiry, your lordship will find, please refer to page 95, please refer to our letter number so-and-so dated 17/9/2012.
Hmm.
Served on you relating to departmental inquiry for allegations as raised against you while you were working as senior assistant at our Dumduma branch. It has decided that further inquiry be conducted by the inquiry authority Sri Rodhiram Panging to
It
cover
is the same inquiry officer.
same inquiry officer.
Hmm.
Only thing, your lordship, it says some aspects, your lordship.
Hmm.
It has not disclosed what are those aspects
Hmm.
which needs further inquiry. Your lordship.
Okay.
Any issue, further inquiry will have to disclose the aspects which they are going to cover. Now, in the name of this further inquiry, your lordship, they have virtually started a de novo inquiry, your lordship. And ultimately, your lordship will find that out of this, if your lordship kindly come to page lordship will kindly come to page 110, your lordship.
Hmm.
Inquiry officer found allegation 3, 4 as not proved,
Hmm.
and allegation 5 partly proved, your lordship.
So inquiry report is just before that.
Lordship,
Hmm.
before that.
Hmm.
Now, disciplinary authority, this time also, your lordship, concurred with regard finding of the inquiry officer with regard to allegation number 3, but so far as allegation 4 and 5 are concerned,
Disagreement.
it is that.
Hmm.
And Stokoe was issued, and I immediately replied to that.
Hmm.
And thereafter, lordship, order of dismissal was, punishment of order of dismissal was inflicted on me. Now, your lordship, my case, your lordship,
Just a moment.
my case, your lordship, hinge on your lordship, 3 aspects, your lordship, 3 grounds. First,
Hmm.
your lordship, the manner in which further inquiry was conducted, this is bad in law, Your Lordship.
Hmm.
First of all, further inquiry, when there is a question of further inquiry, the departmental authority will have to
Hmm.
point out and explain in the so-called notice by issuing a so-called notice to me again,
Hmm.
why they could not accept the report of first report, Your Lordship. That is not there.
That means
Second,
you mean to say that before they proceed for the further
further
inquiry, a show cause
there
notice
should
is,
be notice with the grounds for which, on which the disciplinary authority disagreed with the report of the inquiry authority, that,
there is no disagreement here. It's just a pointing out of the lacuna.
no, Your Lordship will kindly see, Your Lordship.
Disagreement would come in if there is no further inquiry, materials available, he draws the conclusion and then gives it to you.
No, Your Lordship, why it will
I
be.
can understand one thing, that it is vague. To that extent,
That-
fine,
that
we
is-
can accept that.
And secondly, Your Lordship will kindly, will find out from the record, definitely, Your Lordship, that Your Lordship, when I have been exonerated in the first inquiry, if they go for the second inquiry or further inquiry, whatever it is, there will have to be a disagreement, Your Lordship.
So your first contention is that the further inquiry manner is bad
Bad.
because a show cause notice was not issued to you,
Issued to-
and that the order is itself also back as to where actually the lacuna was.
Lacuna, that they may have put it in their own note sheet, that's a
That's
different
a
matter.
different- Hmm.
I will have to be informed about that. And by
Then-
that way, principle of natural justice has been
Okay,
violated.
then
Now, Honorable Apex Court has also been.
what are the
saying-
decisions you are relying on this point?
Lordship, I will be handing over. One decision is KD Pandey, Your Lordship,
Hmm,
and then Kujendra Dole,
hmm.
and Your
Our
Lordship.
High Court.
Our High Court, Your Lordship. Kujendra Dole, Your Lordship, and then Your Lordship, one KR Dev, Your Lordship.
Kujendra Dole, agriculture.
Yes. It will be.
So we'll finish up the first point, then go to the second one.
Lordship. KD Pandey, Your Lordship, para 5. First judgment, Your
Hmm.
Lordship.
Hmm.
All judgments, in fact, are, Your Lordship, I am relying on this point only, Your Lordship.
Hmm. Okay,
Para 5, learned counsel for the appellant contended that in the case, in this
you are
case.
still in service if the,
No,
or
I have-
you retired.
Learned counsel for the appellant contended that in this case, the board had examined the material on record and come to the conclusion that 4 of the 6 charges could be proved on the available material which had not been properly examined in the earlier inquiry. In fact, from the order made by the railway board as well as from the part of the file where the inquiry report made earlier is discussed, it is clear that specific findings have been given in respect of each of the charges after discussing the matter. And if that is so, we fail to understand as to how there could have been a remit to the inquiry authority for further inquiry. Indeed, this resulted in second inquiry and not a further inquiry on the same set of charges and the material on record. If this process is allowed, the inquiries can go on perpetually until the view of the inquiry authority is in accordance with the disciplinary authority, and it would be abuse of the process of law. In that view of the method.
Got it.
I think that is the one judgment, Your Lordship. In Kujendra Dole, Your Lordship, Your Lordship will kindly come to para 5, Your Lordship, page 4 of the compilation, Your Lordship. This is Your Lordship DRD, Your Lordship.
Mhm.
Para 3. Here, Your Lordship, there is a ground that in the disciplinary proceeding, Your Lordship, in the some service disciplinary appeal rules, Your Lordship. Para 9, Your Lordship, relying on KD Pandey, Your Lordship, this honorable court has Para 9, Your Lordship.
Hmm.
The impugned order dated 13/8/2010 has been noted above. The inquiry officer has exonerated the petitioner from all the 5 charges under Rule 9 of Assam Service Discipline Appeal 1964. On conclusion of the inquiry, the inquiry authority shall prepare a report of the inquiry recording his findings on which all the charges together with the reasons to therefore. Thereafter, the inquiry report is to be submitted to the disciplinary authority under Rule 99. The disciplinary authority is to consider the report of the inquiry and record of his finding on each service. Nowhere in the said provisions any power of the disciplinary authority is contemplated to set aside the inquiry report and then to order for further inquiry by appointing another inquiry officer, as has been held by Apex Court.
The only aspect difference is
Yes,
that it was the same inquiry. Okay,
And then Your Lordship, KR,
KR
Your Lordship,
that
it's-
is not
Lordship.
exactly applicable.
Para 12, it only says, Your Lordship, what is, when this
It
second
has made a
inquiry came.
distinction between a further inquiry and a fresh inquiry.
Lordship. That is, para 12, it says, Your Lordship, if there is an, it seems to us that Rule 15 on the face of it really provides for one inquiry, but it may be possible. In a particular case, there has been no proper inquiry because of some serious defect has crept into the inquiry or some important witnesses were not available at the time and the inquiry were not examined for some other reasons. The disciplinary authority may ask the
We
inquiry.
got it, Mr.
Lord. And then
Next.
Your Lordship, one case, Your Lordship will kindly come to next case, Your Lordship. Here it is a case relating to Your Lordship will just, I will rely on one paragraph, Your Lordship.
Decision, which one?
This is Your Lordship, 2014-10.
Vijay Shankar Pandey. Para?
Para, Your Lordship will kindly come to para 24, Your Lordship. Again, Your Lordship, this is a reliance on KRW, Your Lordship. Your Lordship will, the same principle. Your
Para?
Lordship. Para 24, 25, 26. Your Lordship, these are the 3 paras, Your Lordship, I am relying. Now, Your Lordship may kindly,
You want to emphasize that merely because the report is not
Lordship,
acceptable, there cannot be a further inquiry or a
Lordship.
fresh inquiry.
Lordship,
Why the report is not acceptable, that has to
that
be.
has to be, and Your Lordship will kindly come to Your Lordship. Your Lordship may kindly come to next judgment, Your Lordship.
Hmm.
This is relating to
Kunja Bahari Mission.
Lordship. Here Your Lordship will find
Disagreement.
Lordship. Para 17, Your Lordship. And before that, para 16, Your Lordship. The question in Karunakar case, Your Lordship, that's Your Lordship, that famous case, Your Lordship knows, don't. Question arose whether after 42nd Amendment Constitution, when the inquiry officer was other than a disciplinary authority, was the delinquent employee entitled to a copy of the inquiry report of the inquiry officer before the disciplinary authority?
You can skip 16, you can come directly to 17.
Lordship. No, Your Lordship, kindly, Your Lordship, page 44, Your Lordship.
Hmm.
The reference to this, Your Lordship, the earlier judgment, Your
Hmm.
Lordship. The reason why the right to receive report of the inquiry officer is considered an essential part of the reasonable opportunity at the first stage, and also principle of natural justice, that the findings recorded by the inquiry officer form an important material before the disciplinary authority, which along with the evidence is taken into consideration by it to come to its conclusion. It is difficult to say in advance to what extent the said finding, including the punishment, if any, recommended in the report, would influence the disciplinary authority while drawing its conclusions. The findings further might have been recorded without considering the relevant evidence on record or by misconstruing or unsupported by it. If such a finding is to be one of the documents to be considered by the disciplinary authority, the principle of natural justice required that employees should have a fair opportunity to meet, explain, and controvert it before it is condemned. It is the negation of the terms of justice and denial of fair opportunity to the employee to consider the finding recorded by a third party like the inquiry officer without giving the employee an opportunity to reply to it. This is important, Your Lordship. Reply to it. Although it is true that disciplinary authority is supposed to arrive at its own finding on the basis of the evidence recorded in the inquiry, It is also equally true that disciplinary authority takes into consideration the findings recorded by the inquiry officer along with the evidence and record. In the circumstances, the findings of the inquiry officer do constitute an important material before the disciplinary authority which is likely to influence the conclusions. If the inquiry officer were only to record the evidence and forward the same to the disciplinary authority, that would not constitute additional material before the disciplinary authority of which the delinquent employee has no knowledge. However, when the inquiry officer goes further and record his finding as stated above, which may or may not be based on evidence on record or contrary to the same or in ignorance of it, such findings are an additional material unknown to the employee but are taken into consideration by the disciplinary authority while arriving at its conclusion. Both dictates reasonable opportunity as a principle of necessary justice. Therefore, require that before the disciplinary authority comes to its own conclusion, the delinquent employee should have an opportunity to reply to inquiry's finding. This disciplinary authority is then required to consider the evidence on the report of the inquiry officer and representation of employee against it. Then the observations are clearly in tune with observations in Bimal Kumar Pandit case quoted earlier and would be applicable at the first stage itself. The aforesaid process clearly brings out the necessity of the authority, which is to finally record an adverse finding to give a hearing to the delinquent officer. If the inquiry officer had given an adverse finding as per Kornakor case, the first stage required an opportunity to be given to the employee to represent the disciplinary authority, even when an earlier opportunity had been granted to them by the inquiry officer. It will not stand to reason that when the finding in favor of the delinquent officer is proposed to be overturned by the disciplinary authority, then no opportunity should be granted.
Now you come to placitum D,
Your Lordship.
when like.
Which line? Your Lordship?
Placitum
A.
D, when like.
When, like in the present case, the inquiry report is in favor of the delinquent officer, but the disciplinary authority proposed to differ with such conclusions, then that the authority which is deciding against the delinquent officer must give him an opportunity of being heard, or for otherwise he would be condemned unheard in departmental proceeding. What is ultimate importance is the finding of the disciplinary
So
authority.
you are trying to interpret this words
Yes.
to say that when the first inquiry report was given, whatever view you have taken, because that view did not culminate and you have taken a contrary view to what is there, you should have given me a notice.
Notice.
You are trying to develop that argument.
That is
for me.
my entire case, Your Lordship.
Okay.
And then para 18 also, Your Lordship. And this has been.
Just a moment.
In next judgment also, Your Lordship, this has been relied on, Your Lordship. SBI and others versus Aravind Shukla.
Yes,
This only reiterated the earlier.
this judgment is, the proposition of this judgment is para 17 placitum D.
Lordship, placitum D.
Anil Kumar Ghosh. This
No.
also reiterates the,
Same principle. Now, Your Lordship will kindly. There may be, Your Lordship, that there, so far as the bank employees are concerned. the
loss of confidence.
Lordship, loss of confidence, that's an important factor, Your Lordship, no doubt about that. But will that, Your Lordship, absolve them from, Your Lordship, following
Following the
the
procedure.
due process of law, Your Lordship? That will not, Your Lordship, in my humble submission. Therefore, Your Lordship, from the point of issuing for notice for further inquiry, this inquiry proceeding is bad and liable to be set aside and quashed by this honorable court on the ground of, Your Lordship, principles of violation of principles of nature and justice, Your Lordship. And that is what the honorable apex court has postulated in these judgments I have already relied on, Your Lordship. Now, Your Lordship, one second point, Your Lordship, which I want to urge, Your Lordship, apart from that,
Hmm.
that is on merit also, if Your Lordship will find, see, Your Lordship, kindly come to my reply, Your Lordship, that I have given. Before that, Your Lordship may kindly come to page 87, Your Lordship. What has they done, Your Lordship? That why I have pointed out the charge number 5, Your Lordship. For 4 years, they have not quantified the loss, Your Lordship. They are still saying that loss that will occur too. That is basically presumptive in nature, Your Lordship. Then even in the inquiry report, there is no clear-cut finding that this is the loss, Your Lordship, they have incurred, Your Lordship. That is there, Your Lordship. Now, why this is important, Your Lordship? After
Mr. Photo, I'm just interrupting you. Page 87 to page 94.
Lordship.
This is the only inquiry proceeding
Lordship,
held.
This is the inquiry.
Beyond this, nothing. Sure.
So
we'll
far
ask
as
Mr.
my
Talda.
instruction goes, this is.
We'll ask Mr. Talda also.
Lordship. Lordship. Now, your lordship, what they did, your lordship, in the first inquiry, your lordship, which they have abandoned in the midway, there is no documents at all, your lordship will find, your lordship. When defense representative ask for certain documents, your lordship, they say these are not available to us. The moment these were put to them, your lordship, then probably they have reported it to the disciplinary authority. Then ultimately disciplinary authority abandoned this. Then they come up with the next inquiry.
Mm.
In the next inquiry, your lordship.
And these two happens with regard to the amended show cause notice.
No, so now your lordship will kindly see the moment they have gone for fresh inquiry, your lordship, departmental proceeding, your lordship. Then what happened, your lordship? This time also they could not bring the persons from whose accounts the amount has been debited, your lordship. Before the inquiry officer, your lordship, as a witness, that we have put to your lordship, and we have specifically asked them whether you have the copies of the complaints. So, your lordship, what they did, your lordship, those were also not present there. That is why, your lordship, the inquiry officer, when the first inquiry report was submitted, exonerated me from the charges, your lordship. Now, all these complaints, your lordship, are obtained after, your lordship, this is abandoned, your lordship, fresh inquiry was, your lordship, further inquiry was given.
I give them that benefit.
Lordship.
Let's give them that benefit. That transactions were made. There is an allegation that you made the transaction without authorization. That is an aspect which can be proved. It's not required that the employee should come in.
Lordship.
Or sorry, the customers should come in. It's difficult to get the customers. The bank can do it through its employees.
Lordship.
Authorized employees who knows about it,
Lordship.
they can do it because if you are not authorized, somebody was authorized there. That somebody authorized can come and say that I have not done it. Mr. Bhattacharya has done it on his own. Right?
Lordship.
So don't dwell into that. Dwell actually what had happened in the inquiry. What materials were placed before the inquiry officer by the prosecution or by the management to come to a conclusion against you, and how it was placed.
No, your lordship, these were placed, your lordship, that your lordship will find that I don't have the, your lordship will find that your lordship will have to go. to
Your
the-
answer is in page 87.
Lordship.
We'll come to that.
No.
So this 87 to 94 is the only document
No.
with regard to that inquiry proceeding.
Lordship.
Beyond this, nothing is there.
Lordship.
Fine.
No,
Second
your
point
lordship,
taken.
there will be which are not part of here, your lordship. That is, your lordship, that part of further inquiry, your lordship.
No, this is the first inquiry.
This is the first inquiry. Then your lordship will kindly come to
Okay.
95, your lordship.
This is the further inquiry.
Further inquiry proceeding, your lordship will have to go through the record, your lordship.
Okay, let us see what is there.
Only thing, your lordship, in the inquiry report, your lordship, there are reference to it, your lordship. At the end of the day, your lordship, my case is this, your lordship,
They have made it up.
lordship. They have
The
made
further inquiry, they have made it up.
it up, your lordship. They have made it up, your lordship,
Do you know what was the defect in the first inquiry?
lordship.
The documents were produced by the PO
Lordship.
and it was exhibited by the EO.
Your lordship.
There was no witness.
Yes.
But
That is
here,
why here, your lordship, they have meet up the lacuna, your lordship, in the person. And whether that is also permissible or not, your lordship, that's a question, your lordship, that needs.
so if there was no witness in the first inquiry, that evidence will be of no use. That will be a nullity.
Lordship. Now, your lordship, even otherwise also, your lordship, I did not bring that judgment, your lordship, but it is the principle of law, your lordship, that if there is a further inquiry, your lordship, the moment they use the word further inquiry, the other inquiry report subsists, your lordship. it will be and the subsequent report will only be an addition, Your Lordship.
No, it will be a report after also taking into account that further inquiry, materials coming into the further inquiry.
Lordship.
So they will furnish it will be a fresh report, but here the further inquiry part, whatever it is there, he will draw conclusions on that and then modify the whole thing.
Lordship. But Your Lordship, they will have to refer to the earlier inquiry, Your Lordship, at the end of the day. Now, the moment they use the word further, Your Lordship,
Hmm.
that may, just Your Lordship, an analogy from the criminal proceeding, Your Lordship.
Hmm.
When police submits an search
Supplement.
sheet, submits a search sheet, Your Lordship. Now, thereafter also police under.
No, we can use it in another way. A fresh investigation is not permissible,
Not permissible.
but the CJM or whoever is accepting the charge sheet can ask for
For
a
a
further,
further inquiry, Your Lordship.
further inquiry.
Further inquiry.
When a further inquiry is made, then it's not only a supplementary charge sheet that is filed. They file a proper by incorporating that aspect of the matter.
But Your Lordship, Supreme Court says, Your Lordship, the moment it is further, the earlier inquiry
Will remain,
No.
but the lacuna which was pointed
Yes.
with the lacuna that
Or
will
the
be
aspects.
permitted to.
They
Come on.
can, Your Lordship. Now, here is the case, Your Lordship.
Hmm.
My case is that the further inquiry they have conducted.
Mr. The second point of yours, let us just go fast through the inquiry report.
Course. Page 96, Your Lordship. Starts from page 97.
Hmm.
Allegation 1, that on 16/10/2009, you without any valid mandate for the depositor had made unauthorized debit of rupees 6 lakhs by way of 12 entries of rupees 50,000 each using your ID number so and so, account number so and so. Documents relied upon by PX1, here reported at 16/10/2009, system generated cost wholesaler number so and so, statement of account number so and so. User amendment reported at 16/10/2009 and 17/10/2009 under section 65 of the Indian Evidences 1872. Any information contained in electronic form which is printed on paper, recorded or copied in an optical magnetic medium produced by the computer shall deem to be documents admissible for any proceeding without further proof of producing the original as evidence. As such, the considering the documents relied upon, the presenting officer is of the opinion that CSC had made unauthorized debit of rupees 6 lakhs as well as. Here, pausing for a moment, Your Lordship, they have relied on, Your Lordship, section 65 of the that Lordship.
That is neither here nor there.
Lordship.
Okay,
Referring to
first charge I have gone. Let's come to the second one, page 99.
second also it stands proved, Your Lordship. Page 99, Your Lordship. Inquiry officer's remark.
Now, a customer has come down.
Lordship, customer has come. All the customers have ultimately during further inquiry come. And some say they, and these are all, Your Lordship, I have taken a specific plea in my reply that all these were, Your Lordship, brought after the direction for further inquiry, Your Lordship, and one or two, Your Lordship, customer has categorically stated that I don't know what is written in my complaint, Your Lordship.
So, Mr. Vathakot,
Lord.
one question. Subject to this court accepting your plea with regard to that further inquiry, say we reject it. We say that is not sustainable for X, Y, Z. Is there any perversity in the inquiry officer's report? You forget the part whether they could have gone or not. Why I am saying so? If we come to a conclusion that the further inquiry in the facts was permissible, then the next question would be the inquiry report. So then it would be proportion. Third would be proportion. Now, for going into the inquiry report, I will have to be satisfied that there was perversity. That evidences, one was witnesses, not through witnesses, that is gone.
Gone.
So now the only issue left is I can go into the conclusions.
Lordship, Lordship.
If the materials are there, the conclusions, I can't sit upon appeal. So the only question is there any perversity?
Lordship, to be honest, Your Lordship, that I can't say that, Your Lordship, as such there is.
Just the thing, because if you argue perversity, then I'll go into it.
Lordship, no, your lordship will kindly say the perversity is that once your lordship, the witnesses were brought. Accept the fact that all these complaints, your lordship,
We get it. That is in the periphery.
lordship,
I'm in the meat.
lordship,
Now, if I hold that the further inquiry was not permissible,
Yes.
all these things falls true.
lordship.
But if I hold that the further inquiry in the particular sense, although there was a lacuna, just trying to clear my cobwebs, there was a lacuna in that order. But still, the authorities proceeded and you were given an opportunity. Now the question would be, in the further inquiry, the inquiry report that came in, one, you have not alleged anywhere that you were not given a due opportunity.
No,
So that is gone.
that is not.
So the only thing that I can accept is a
Perversity.
perversity.
Lordship will kindly see your lordship so far as the perversity question is concerned. If we accept that the evidences subsequently brought into record, your lordship, that is, that there is no violation at all, your lordship, that this, suppose your lordship, the fact that all these allegations, your lordship, that the complaints are, your lordship, after the further inquiry was directed to be conducted against me. If-
No, I'm dehoused that.
No, lordship, if your lordship hold, that it is proper, your lordship, then there will be no perversity.
That much.
And if your lordship hold. that
If I hold that the inquiry report 2003 May, that order is bad, it goes, everything goes. Now, what about proportionality?
So for that, on that. your
Because
lordship,
if you see, if I hold that the page 87 or 86, that letter order of the disciplinary authority proper, no perversity, then the question would be proportionality.
Proportion.
But you are a bank employee.
Yes.
If I hold that 2 point against you, proportionality will not come in because there is loss of confidence. Any other judgments?
Lordship, accept that, your lordship, my another point, your lordship, which I want to place, your lordship, if your lordship kindly see, at the end of the day, your lordship, when the question of inflicting a punishment comes up, this disciplinary authority, your lordship, will have to look into, your lordship, proportionality in that sense, your lordship, that the balancing test, your lordship.
Unfortunately, I have held against you on that point in 2 cases. 2 na 3 ta Banko 3 ta na 3 ta. 3 cases wherein I have come to the conclusion that I've quoted the Supreme Court judgments and said that when there is a loss of confidence in respect of a bank employee, loss of confidence in respect of a government employee, it's a
That's it.
different. But bank employee, even if it is 1 rupee, enough. No further
No.
is, and I have rejected the prayer of proportionality because it was urged before me, proportionality. When I found that there is a loss of confidence occasioning, I have dismissed it.
No, I am not on that, your lord. That may be, your lordship.
But you say that the inquiry, the disciplinary authority while doing it ought to have considered
the factors, your lordship, ought to have balanced everything, your lordship. My past career, your lordship, and ultimately, your lordship will kindly note, your lordship, there is a criminal case arising out of these transactions, your lordship.
Hmm.
I was acquitted, your lordship, in these cases. Maybe, your lordship, it is not a factor as such, your lordship, to be considered in disciplinary proceeding. But at the end of the
imposed,
day,
exonerated on honorably or in doubt.
it's a benefit of doubt. your lordship. It's a benefit.
Will not bring it.
Lords. That's why I have not brought that
No,
order
yeah.
and not shown it, but it's a benefit of doubt. And
So-
one round, your lordship,
Hmm.
where probably, your lordship, in my humble submission, I stand. I have some footing, your lordship, that is on the point of giving, your lordship, further inquiry without.
That's what I just wanted you to come back to that page, 95. Let us read it once.
Loss,
Because now your case stands or falls on this page.
loss. Please refer to our letter dated so and so 79, served on you relating to department for allegation of alleged against you while you were working as senior assistant at our Dundua branch. It has decided that further inquiry be conducted by the inquiry authority, Sri Dodhiram Panging, to cover some aspects which are left in the inquiry till date. Accordingly, I have ordered to hold a further inquiry into the charges leveled against you and have advised the Dodhiram Panging SMGS4 Inquiry Authority under the previous provisions of the Sastri Award as modified from time to time and various settlements which are applicable to you. Sri Dodhiram Panging therein Paul Enquiry is at present posted and so and so. The bank case will be presented by presenting officer Shibendu Das as hitherto and presently posted as branch manager of the Moran branch. The venue, date, time, holding of the inquiry and recording of inquiry proceeding will be fixed by the inquiry. If given a fair and reasonable opportunity to produce your defense by oral and documentary evidence relating to the service, will permit it to be defended by the representative of the.
Okay.
district.
Anything more, Mr. Bhattakur?
And your
This is the
lordship, and
case.
ultimately, your lordship will also consider one aspect, your lordship, when I am arguing on principle of nationality, I have sought from certain documents from them, your lordship. And here, I have put to them, your lordship, certain questions. For example, your lordship, the questions relating to the CCTV footage, your lordship. Now, we have asked them specifically, they provide us the footage of CCTV footage.
No, one thing, if that is your argument, just on
Then
merits,
that's also
no,
one.
no, just on merits. The allegation against you is that the transaction was used by your ID.
ID.
What was your answer to that?
No, that I have not done. That I have. My question is that you are only.
I got it.
No,
I got it.
lordship.
But when we have the meat with us, why
No.
should we go for the skin?
Lordship, that this is why, your lordship, my specific case in my reply was that some other persons, I have named them, your lordship.
Your
that they-
ID, nobody can use
No,
other than you.
no,
And if somebody has used it, then Mr. Bhattakur, you're not fit to be a banker.
No, your lordship, that at one point of time, your lordship will kindly see, these are relating to 2008-9, your lordship. That point of time, your lordship, everything was new for these people, your lordship. And this is at a branch called Dumduma.
A remote area.
These things, your lordship, we admit or does not admit, your lordship,
On a lighter vein,
lordship.
it is easier to do these acts in a remote area than do it in a town area. Okay, fine.
This
We'll
is-
come back to you.
lordship.
Yes, Mr. Halda. Mr. Bhattakur was very fair. So his case is basically on page 95.
Second.
Second, further inquiry.
further inquiry.
So his case, as I have understood, is that, okay, you go for a further inquiry, there is no problem. But what was the lacuna? Where do I get that? Where does he get that?
That is the point, Lordship. It was in fact a technicality of the use of ID.
No,
When,
not on that, sir. What I'm trying to say is, you had an inquiry.
Lordship,
It culminated in an inquiry report. Whatever is there, that inquiry report. Then the disciplinary authority in page 95 was not satisfied.
not satisfied.
So he says that there has to be a further inquiry. Now, further inquiry cannot be a re-inquiry. It has to be on an identified parameter. What is that identified parameter?
Lordship, what happens in the basic allegation was that he used his ID to manipulate the accounts of the bank customer. That is one thing. When it was the basic point of charges, then Lordship, when those were not considered, what other evidences are required, that is the thing where the disciplinary authority was dissatisfied and made an order for further inquiry. That is one thing. Next, Lordship, this further inquiry, my learned friend has said that ought to have again issued so cause or.
No, he is not saying that. That will be a fresh and de novo inquiry.
Yes,
De novo inquiry is not permissible.
that should have
He
been
is saying-
informed according to him.
No, he is not saying that. He is saying that you have said it has decided that further inquiry be conducted by the inquiry authority, so and so, to cover up some aspects which were left in the inquiry till date. Now, what are that some aspects? Where is that specification or direction from the disciplinary authority to the inquiry officer that, see, these are the aspects you have left out? Give me the clarification. Or hold up
It is-
further
it is-
inquiry on that
it
point.
is Not specifically mentioned.
Then it amounts to a re-inquiry, a fresh inquiry, literally. De novo inquiry, care de says you can't do that. Mr. Bhattakur has brought out a very thin line, but he has brought out a point.
It's very thin line. No
Thin
doubt.
line. That is his brilliance.
That is the thing, Lordship.
That is his brilliance.
But one thing, so far the case is concerned, so far this technicality. However, in the second, that means the further inquiry, in the further inquiry, he has submitted and all opportunities were given.
That I have told him already. He has that second inquiry report, there is no perversity. But tell me, where do I get the mind? I understand the mind of the inquiry or the disciplinary authority with regard to these words. Further inquiry to cover up some aspects. What are those aspects? That much only. Even if it is not specified here, even if you have it in your contemporary records, I'll go against Mr. Bhattakur.
Lordship,
Because he is a bank employee.
Lordship, the second para says that you will be given fair and reasonable opportunities to produce your evidence by oral or documentary.
Sir, I'm
etc.
not on that. What I'm on is
I understood.
what he is to meet. What is that issue or the points for further inquiry?
Further inquiry, in spite of evidences, in spite of all the charges are
That we
almost
can,
same or similar.
no, sir, that we can infer from the inquiry officer's report as to what he has done. The lacuna was there was no witnesses. The documents were taken from the PO directly and the EO had made it exhibits. Now you have brought it on record by way of witnesses. So Rup Singh Negi satisfied. Right? So these are legally admissible evidences now. But where have you stated that?
That is not there, of course, Lordship.
So what would be an answer to that? To justify page 95. You have the records with you, sir. Wherein,
Inquiry report is there.
no. Wherein this letter was issued. 6/5/23 was it, 2013 was issued.
That entire file is not with me.
So you will have to get that. Even if it is there in the contemporary records that I have examined, but these witnesses, or even if he simply says that, see, this evidence is inadmissible, you must have it through witnesses. Your witnesses were there. In the show cause, any witnesses were named?
No.
No. Charge sheet, no witnesses were named. My job is very easy. It's only page 95.
That is there. The question is that the fact is that it cannot be denied that nothing happened, Lordship.
No, we are not on that.
That
We are on a technical
So
point.
far, no, so far the proceeding is concerned, he has availed all the opportunities.
Fine, sir. But there is an inquiry report in his favor. First inquiry report, according to him, in his favor. That was not
Not all.
accepted.
Not all charges, Lordship. Not all charges.
Where is that first inquiry report? And Mr. Talda sir, you satisfy me on this point and not go into any other aspect.
That's the first inquiry report.
And then I'll say loss of confidence and we will have Mr. Bhattakur out, subject to appeal.
That is a different issue. It is a course of justice, Lordship, in the long run. What
But,
happened, that will
I
happen.
got to be
But,
satisfied on this
it-
point.
It is my duty to satisfy the court.
Only on that point, sir. So if you don't have it,
No, Lordship,
first inquiry report.
this is they have submitted, Lordship, as first inquiry report. It is not that reflective there. It was furnished to me as first.
No, this is the second inquiry. Okay. Okay, this is the first inquiry. No, this is the second inquiry, sir. Prosecution witness comes in the second inquiry.
They have submitted it as first inquiry report to me.
Hmm?
They have furnished this to me as a first inquiry report. Some charges are not proved in this report.
This is the first one. This is the first one, sir. And where is the records with regard to this letter? 6/5/2013, page 95.
It's not there perhaps.
It's not here.
But all charges were not exonerated in that report.
Here, charge number 1, not proved. Charge number 2, not proved. Charge number 3, not proved. Charge number 4, not proved. Charge number 5, not proved. Very casually done. First one.
That is there, Lordship, but non-use of ID was not a question, defense question. And that is the reason.
He will not ask that question because that will go against him only.
The main issue. was
Can you
actually-
get me the records of this from where the 6/5/2013 was issued?
Okay, Lordship.
Hmm?
Okay.
Friday?
This Friday.
Because I'm not here from next week. If I can conclude it, I can reserve it and pass the order,
Lordship.
right? Only for that
Let me
records.
try, Lordship.
Any judgments, sir, you want to rely?
Lordship, so many judgments are there. So far, bank employees conduct is concerned.
That is understood. Any other on this point of further inquiry and
On-
pressure?
On this point,
No.
Lordship, I don't have. At the present,
If you have anything, you can just give it to me on Friday.
Lordship.
So this is it.
No, this-
We'll only satisfy ourselves with the records and then pass the order.
no.
Heard the learned counsel. at length. Full stop. Mr. L. Talukdar, learned Standing Counsel SBI submits that an endeavor would be made by him to furnish the file from which the communication dated bearing number R dash Roman 3 Badawala oblique HR oblique 560 dated 6/5/2023 was issued by the disciplinary authority. So accordingly, list this matter again on Friday for further hearing. So this is the, we have concluded. I heard the parties at length below ऊपर में लिख दूं.
Deeply applied.
Can I keep this?
Lordship.
এইটো তিনটা ভালকে বান্ধি এই তলফালে সোমাই দিয়ে. So Mr. Bodhakur,
Lords.
only on page that 13 letter, nothing more. And I'll note that your perversity point.
No, your
Although
lordship, I
that
have your-
proportionality thing we will say,
Lords.
and perversity and proportionality, we are not going into. We are only examining whether the further inquiry was proper. If sir can satisfy me with that documents that yes, there was and there has to be. I've seen the first inquiry report. The question is there is no evidence. Very casual.
Lords.
But
No,
anyway,
your lordship, that, my reliance will be on that judgment.
I'll see.
Obliged, Lordship.
Anyway, we'll have to see the meat of the matter also.
Lordship.
We'll see. So you get me that. Havildar PSO.
My lord.
Yes.
Now, lordship kindly see, my lord, first at page 15, my lord.
50?
15,
15.
page 15, my lord.
Hmm.
My lord, similarly situated person, officer as Havildar, they have given, my lord, great pay rupees 2,400.
But this is not Havildar PSO.
But now our case is lordship on page 19.
Hmm.
Page 19.
Hmm.
Here says, my lord, PSO
Havildar.
stroke Havildar.
Now you come to the affidavits.
Yes. Affidavit say it has been provided to
30,
the
Page 30.
commissioner. Yes. My lord,
And this
there-
post is only available in SB headquarters.
Only SB.
para 5, my lord, their affidavit.
No, no, no. Come to page 30 of their affidavit. Annexure 3. Internal page 8.
Internal page 8. Home Department, Annexure 3.
Hmm. Additional DG, Special Branch informed that they have a cadre of PSO Havildars who are given pay in PB2 with grade pay of 2,200. It was 200, 2,000, they increased it by 200 rupees. Havildars are promoted from the rank of constable and get a pay of rupees GP 2,400. This is a different aspect altogether. Total number of posts is 1,500 and present about 300 posts are vacant. Out of the remaining incumbents, 624 were regular Havildars in the battalion and were drawing GP so-and-so. The others were promoted from the rank of constables with relaxed qualification, say category 2. Havildars category 1 are not getting the same GP because PSO Havildar posts have GP of rupees 2,200 only. As such, they are losing financially. Other Havildars are not entitled as per rules and therefore face stagnation. Therefore, PSO cadre has become, its effectiveness has become a matter of concern for the special branch. Now you see, it does not recommend increase. It only says that identify the persons who are eligible, train them, post them. So,
Now, their affidavit lordship will find para 5.
Hmm.
May I read, my lord? That with regard to the statement matter in paragraph 6 and 7 of the writ petition, the department stated that it is a fact that the petitioner was absorbed against the vacancy of so-and-so PSO Ashok Havildar of this organ, as there is no post of GD Havildar in this organ. The grade pay of so-and-so rupees so-and-so as per ROP rule 2010, and accordingly the petitioner has drawing gate so and so open as to the ROP rule 2010. Moreover, in connection with the Assam Rifles, Ulubari, Guwahati was removed regarding the clarification of the grade pay of the PSO Havildar and the driver constable and organization. But the Assam Police Headquarters, so and so, Guwahati later intimated the grade pay of the driver constable, Mr. Havildar, further to revise so and so, respectively. Further to remove the
2017
difficulties, the grade pay of the PSO Havildar cadre, the matter has already been placed before the 7th pay and productivity pay commission. The report of the 7th pay and productivity pay commission was submitted to the government of Assam on so and so of the version of.
So
the
this is the report. What was the final, how was it accepted by the government finally?
Yes, that is not Malad.
That- Get me that ROP rules, that will finish it. 2017, get it from the library. We'll take it up after some time.
Malad.
That 2017 ROP rule book,
Yes.
that you get it.
I'll-
Recommendation we can't act upon.
Before
Where is it?
What happened to the
Yes,
cabinet?
my lord. My lord, initially 5 names were forwarded, my lord.
Hmm.
Now they have advised, my lord, only one writ petitioner is there.
Hmm.
Therefore, they advised to propose only writ petitioner's name, my lord.
You get it done in that way. We can't do
Yes,
anything
yes,
for
yes,
you.
yes, my lord.
Pray for an adjournment. That's only I can do.
My lord.
Third day, Learned Council for the parties, Mr. S. Dr. Learned Standing Council, PNRD Department submits that the matter is being processed for placing the case of the petitioner before the cabinet for receiving approval
Yes.
towards a regularization of his services. Also, accordingly raised it to list this matter after 8 weeks on a date to be fixed by.
My lord. Hello.
We can't do anything.
My-
You are relying on a decision which I appeared, Arpan Chetty
Yes,
has.
All right, my lord.
five,
Time being.
No.
Easier. Mr. Bora, what is the length of a service permissible for a government employee?
42 years.
42 years. You have done 50 plus, 48 plus,
For
47 plus.
47.
You are the person who is responsible.
No.
And the tribunal has come to the correct conclusion. Now you prove me wrong.
Yes, sir.
47, 53.
Yes.
If we
Yes,
take it as 47, your entry is 18 years, 2 months.
Yes.
If we take it as 53,
12 years.
your age is 12 years,
Yes.
not permissible.
Yes, Lordship. Now, Lordship would come to page 19.
19.
Who has done it?
You have done.
Lordship.
You have done.
Lordship will kindly see the letters.
No, we are not going into anything.
There are
And you are
observations-
left off very reasonably.
There are observations in the order itself.
That is an observation made by misrepresentation on your part. We'll hold it.
No, Lordship will kindly see the page 19 for once.
You are not
Oh.
going to get Rafiq Mashik's benefit.
exactly,
No,
my
no,
lord.
You are not going to get it.
Cannot.
Lordship.
Initially, when I was going through, I was with you. But when I found the calculation, I'm little bad in maths. Took me some time to calculate. When I calculated, this is something done by you.
No, Lordship will kindly.
Borpeta, DC Borpeta, DC Borpeta.
Borpeta. I am just a peon, Lordship.
That you are a very powerful peon.
Lordship.
I think you should be taking classes for the other government servants. How to increase.
No.
See, you retired. You retired. You were retired.
Yes.
Then you come up with 53.
He came back.
You go to the DC. The DC might be doing something he signs.
Lordship, kindly
extended.
come to page 19 for once. Well, when it happened, when it started.
Started after your retirement.
No, that is the thing. Lordship, page 19.
Hmm.
Firstly, it's a letter of 14/5/2004.
Hmm.
With reference to the subject cited, I have the honor to state that as stated by Chandrakanta Soikia, his actual date of birth by
Okay, we accept this. We accept this. This
Now
letter
next
we
page,
accept it.
Lordship,
We accept
21.
this.
21 now, BC gives the circle officer to verify.
Hmm.
With the above subject reference, I have the honor to state that I have inquired into the anomalies of the date of birth in service book of Chandrakanta office peon of so and so. I have personally verified the administrative register of Mandya government dated so and so. Hence, the date of birth may be treated as 3953, not 1st September 1954. Accordingly, his service book may be rectified.
Hmm.
Now, Lordship would kindly have a look. Yes, ma'am. At page 25, Lordship.
And Mr. Bora, this type copy of the prior administrative tribunal's order is incomplete. You have not typed out the relevant portion. You come to page
Sorry, Lordship.
88,
18, Lordship.
88.
88. Lordship, yes.
Second paragraph. Consequent upon decision, the impugn order so and so stand null and void. Right? Now you come to your page 66.
66, yes, Lordship. That portion I was citing that in light of the observation, we have.
Where is that paragraph?
In the final conclusion, that a date of appellant has completed. Oh, yes.
So and so 2007 and so and so so and so. Where is that?
Lordship, yes, there is some mistake. So I was going to read the main thing only.
Okay, fine. But the courts which have gone through this matter earlier have only referred to page 66. They have not gone to page 88 because 88, maybe my eyesight is little bit better. I could read it.
No, Lordship, I was also thinking that whether they have interfered with the dismissal order or not.
Okay, Mr. Bora, what is your ground?
Lordship, I'll show that it is a mistake made by the authorities and not me. I have nothing.
Okay,
to-
let us accept that the authorities have made a mistake. Let us accept that.
Uh,
So your entry is 65. That is, there is no mistake in that.
Yes,
Now show me how you could have been engaged in 12 years.
Lordship, yes, Lordship, that period may not be counted
No.
for pension.
It will have to be counted. You can't be below 18 years. Show me the law that you can be engaged as a 12-year-old.
Lordship,
Show me the law.
is a boys service, Lordship.
Boy service will not come in. Because that concept was with the British. That is gone now.
In 79, there is a notification, but it's something before 79.
79, it is not attractive.
But here he joins in 1965.
18 years to 60 years, 42.
40
Maximum upward.
maximum.
You will be 47. Show me the law.
But disciplinary proceedings was also not conducted.
Need not be. Need not be. Recovery is the issue now. Your issue is recovery.
Yes,
So recovery is permissible in these circumstances. Because this is a mistake, this is a misrepresentation made by you. You were responsible.
Lordship, in the Lordship would see in the initial service book also the date was given as 47, but in the service form it was given as 53.
That is somebody helping you out. The initial book which is there, which has been brought, first page, it is below. First page has been incorporated. There is a cut there,
Yes,
right?
yes.
Then
Lordship, what I want, I have no role to play here, Lordship. That is my submission.
we can't accept that.
Lordship, at page 66, Lordship. Lordship, I'll read the main order.
Hmm.
Because again, there will be some. The 680.
What is the thing you want to say?
65,
Hmm.
it is notice 1, 2, 3, 4, 5, 6, 7. 7 line. It is also noticed from the perusal of the record that the then block development officer corrected the original date of birth in service book, and the appellant without receive of any approval from appointing authority to
Hmm.
be to be reflected in the letter by him to the respondent number 2 dated 14/5/2004. Similarly, the service period of the appellant was extended by respondent number 2 on cognizance of the duplicate certificate without taking approval of the government cabinet.
Hmm.
On receipt of a letter from respondent number 3 without proper scrutiny of proper examination of all the relevant facts, figures and accounts pertaining to appellant. No enquiry report was found in the then relevant file produced. This is evident from the above observation that there is serious administrative lapses on the part of the respondent authority standing the service period of the service period of the appellant beyond his pre-scheduled retirement date of 31/8/2007. By the order dated 31/8/2000 without.
And are they making this recovery now?
Lordship,
30%?
initially they made recovery. Now there is a stay order
Here in this court.
here.
Okay. Anything more?
Secondly, Lordship, but that period I also served, Lordship. That is there.
In such a case, we cannot give you a premium. Tribunal is very correct. Try your luck. We'll give our reasons. You try your luck.
Lordship, and the DP, at least DP had to be conducted.
No need.
Enquiry report has also not been furnished to me.
The conduct of yours relevant. It's only the question of overstale. Whether
Yes.
how to do it. For overstale, there is no DP required. It's either whether you are responsible for that or you are not responsible for that. If you are responsible, you are not getting it. If you are not responsible, that extra period will not be counted.
Yes, Lordship, towards pension, but they are seeking recovery, Lordship. I just want to.
No, I'm only on that, the recovery part. When was the? Okay. Okay. Okay.
Lordship, it was done by proper verification, and it was not done on my
Mr.
part of my
Mr.
time.
Bora, that verification itself is perverse.
But the government has accepted the verification.
Not the government. The government had no role here. HC means the government. In FRHC, if there is a requirement to change, it has to be by the commissioner, not by the deputy commissioner.
Change of date of birth, but.
See, read HC. It's the
But-
government.
And in
And
exceptional
here there is
circumstances-
no acceptance by the government at any point of time. So why should the state exchequer bear that?
And Lordship,
You had your days in the sun. Now it's
Lordship would kindly see that I have been retired for so many years now. And I have been maybe in the fade end of my life.
we are only concerned with the issue before us. And Rafiq Mashik says if there is a involvement of yours in the matter, no recovery would be permissible.
Lordship, that is correct that I was born in 1965. 1953, I joined service in 1965. At 12
Then
years
where
of
from did this 1947 come in? Which is there in your service book and which has not been rectified. Your plea was, my records, it got burnt in my house, right? You went for a duplicate certificate.
Yes.
Now, if you want me to open up, I can open up more. Why should we go into all those things?
Yes, Lordship, but ultimately disciplinary proceedings was not done.
Any decision to support yourself?
Lordship knows everything.
I don't know anything.
But still I
only told you what I found.
Lordship, there is a recent decision
Of
of this court whose refers to other Supreme Court decisions also on 25/4/2023. That decision refers to a Bihar judgment at para 12. But again, it's in the absence of misrepresentation.
Okay. Heard Mr. B. Bora, learned counsel for the petitioner. Also heard Mr. Ardhot, learned counsel appearing for the state respondents. Hearing concluded, list the matter, also heard Mr. S. Doctor, learned counsel for the respondent number 7. Hearing concluded, list the matter on Viraspati by DD.
Lordship, in para 16 also of the judgment, I want to just, because was a recovery notice.
See, it's a finding of fact by the tribunal and it's not perverse. Why should I in 226 reverse that?
No, Lordship, but the no department.
We'll take care of that. What your submission, we'll take care of. We will provide an answer for that. Don't worry.
Section 9 was not followed, inquiry report was not given. Therefore, I was condemned, though unheard. Though a reply, chance of reply was given.
Okay. What would have been your reply? I give you 2 charges. I'm giving you. 1, you overstate the maximum permissible limit for a government servant. 2, the age was recorded as 47 and that was not corrected in terms of HC by the government. How can you take benefit of that? What would be the answer?
Lordship, firstly, I was allowed to.
If you want to formulate your answers, I can hear this matter on Thursday. You can formulate your answers. Satisfy me, I'll come in your favor.
Lordship,
Or Thursday, I'll pass the orders. I'm giving you an opportunity.
I'll try and.
Thursday. We are keeping it for delivery of orders,
Yeah.
but I'll give you 10 minutes. You can satisfy me.
Diplo.
Isko le lena, दे दियो.
Please. My lord, SCP NRD may be reflected.
Thursday, it's coming. You come. Yes, Mr. Kaushal.
Here the petitioner
2013.
2013. Since 2013, his promotion was due to the cadre of divisional manager. And all his juniors, his batchmates were promoted in the year 2013. His juniors were promoted in the next year. The remaining batchmates were also promoted in the next year. The petitioner has not been promoted. There is no adverse entry in the ACR. The contention of the respondent in their affidavit is that in terms of the seniority is not a factor, it's the merit. But how the merit has been judged, there is no.
Have you alleged malafide against any of the selection committees, assisting committees?
No.
That
But
how can we go into that? How they have assessed? It's
yes, that is a subject matter where I am challenged.
but
I say that
they
the
tell me
regulation says the
Merit-
suitability will be judged as per merit. As the regulation says, suitability judged from the merit by way of interview, examination or ACR. Interview and examination were not held. It is only the ACR. There is no.
so you mean to say that the grading should be taken?
There is no procedure as such of giving some grading.
So they have devised a procedure.
Though they have not devised anything.
They say
the affidavit-
it's the ACR gradings plus the service particulars.
That is done only in 2016. The comparative statement which they have annexed now.
Now, okay. Why have you not implemented persons who had superseded you, at least in representative capacity? Because they say the posts have been filled up. So if we pass an order today, somebody will have to come down. We are not going to ask them to create a supernumerary post for you. What is your answer to that?
Look, the petitioner has already retired in 2017.
That we are on 13.
Yes. No, the challenge when it was made, immediately thereafter he has retired. Now, my lord, he is praying for the notional benefits.
But notional benefits, if I give you also, I'll have
But
to.
the vacancies were there. All vacancies were not filled up.
That is not pleaded.
No, even the affidavit which they have filed, they
There
say
is
that
no,
they have-
because you have not taken that plea, so they have not replied to that.
No, they have replied. In the affidavit, they have said that there were 181 posts. Only persons who were found to be suitable has been promoted. And all this the promotion list.
That is what I'm
shows-
saying. 181 is there and only persons who have been found to be suitable has been promoted. They don't say that we have not filled up all the 181 posts.
No, the promotion list are annexed.
Promotion
That
list
would
are
be a
NA.
presumption which we'll have to
No,
draw.
promotion list are NA, which clearly indicates, my lord, all the posts were not filled up.
Yes, Mr. Chaudhary.
Also, in the affidavit, we have clarified that aspect of the matter. So the petitioner is referring to that this.
But
Since-
what do you answer? How do you answer his point that the regulation says only grading? And if it is only grading, he has excellent and very good.
No, that we have already answered in paragraph number 10 of the affidavit in opposition. Paragraph number 10, Lordship, in the middle portion, we have made a specific statement with regard to that. In the middle portion, the fifth line from top, Lordship, in paragraph 10. And since seniority is not the only criteria for promotion, as such, the petitioner is not considered for promotion.
Where is the regulation?
Regulation, my lord, I have quoted in this.
No, where is the whole regulation? You have quoted somewhere.
Yes, I have quoted.
Where?
in- The repetition, my lord, will find. Page 10, my lord, para 11. Paragraph page 11, my lord, will find it in bold. Promotion shall be based on merit suitability of the candidate for a particular post and seniority. Merit suitability may be judged by confidential reports and or interview and or examinations.
So the gradings will be of no use.
So it was their statement that grading. I did not say, my lord. My lord, my contention is
Okay.
the repetition of your my lord. will
This
find.
will take some time.
Right.
We'll have it next week. Because if I hear it, if I don't conclude it, I'm not here next week.
My lord.
We'll have it. But Mr. Kaushik,
Well, I'll show a judgment of the Kerala High Court, my lord, where similar situation, in a similar situation.
judgments would come, but the facts should speak first for itself first.
No, my lord, if your lordship will fail, the entire affidavit, what they said that seniority is not the factor. But how in merits, the others were better than me, they have never said. And in the assessing
That is
committee.
why I'm saying that we'll have to conclude
Well,
for that it is only the grading. Because if I go beyond that, if I give the power to the selection committee to make their own assessment, then without an allegation of malice or malafide,
Your
how
lordship
can
will
I?
be- Your lordship will, it's very interesting, the SSC committee's reports, they simply says, these are the person considered and these are the. person
Show me a selection committee report of any selection wherein they have said more than that. Okay, fine.
Your lordship fixing a date, right?
Next week, any day. Tuesday? On the, as prayed for by the Lanark Council for the parties, list this matter again. Tuesday, laga do.
Yeah, the fifth, well.
Fifth, no problem. Mr. Chaudhary, why are you waiting for? What are,
I get 9.
we'll just come back.
My lordship, I'm rendering my service as Anganwadi helper of center number 74 in the Maichanpur Anganwadi Center.
You are for the petitioner?
Yes.
Okay, who is for the respondent? Mr. Barbian. Where is your regular appointment?
My lordship, I have applied my,
Where is your appointment regular? Or as we know, as an Anganwadi helper, it's an engagement. Where is your regular? Your initial appointment is only for 2 months,
2 months.
extended for another 2 months.
I have come against the advertisement, my lord.
If you are not an incumbent in that cadre, how will you be considered for promotion under that policy?
I appeared also for interview and
You come to your appointment order,
page.
page 13, is attached basis for 2 months.
And then page for 15 also.
Then 15, extended by another 2 months. After this, nothing.
Allowed to continue.
Who allowed you? Where is your engagement? Where is that selection? Anganwadi helper also there is a selection required. So if you are not a selected candidate for Anganwadi helper, how can you come within the purview of that promotion policy for Anganwadi worker? And you are working, Mr. Verma,
Yes,
you're working.
really appointed in.
Anything more? Closed. Disposed of. Naam kita lele boss.
My lord, he is also not regular.
Where is your statement to that effect? Mr. Azmiya, you are not regular.
I'm regularly appointed as. In my affidavit, you also.
I've seen it, I've seen it.
In my affidavit.
Come to page 45.
Yes, my lord.
Anything more is required?
That will be year 2007, man.
Right? Anything more is required? Yes, Mr. Swigya. Hmm.
The respondent number 4 has been appointed for the post of senior assistant,
Hmm.
for the post of head assistant also under
Hmm.
the office of the district commissioner, Dibrugarh. In pursuance of the advertisement dated 25/5/2022 laws of NSSC page number 23.
Hmm.
Can you period laws?
Hmm.
Page number 23 laws, that is the basic and basic criteria laws to
Hmm.
be appointed for the post of head assistant also. That is the
Second paragraph.
second paragraph. Candidates who have not completed at least 10 years of service at senior assistant, including supervisory assistant in different branches of the amalgamated establishment of the office of the deputy commissioner in Assam,
Hmm.
not need to apply.
Hmm.
But the respondent number 4 is who is junior than us, Lordship, but we also not rendered as services as supervisory assistant also.
Your case is only that because she does not have supervisory assistant,
Yes,
she will not be given.
yes, Lord.
Supervisory assistant is a appointment coterminous equal to that of a senior assistant,
Yes,
right?
yes.
This cannot be interpreted in that manner.
Head
This
assistant.
says that you should have 10 years of service as senior assistant. And during that period, if you are working as a supervisory assistant also, that will also come within 10 years.
Homologated to be head assistant also.
To be
That is the
promoted.
Basic criteria lordship as mentioned in the Assam district
Assam rules.
establishment lordship under rule
6.
6 sub rule 2 lord. Sub rule 2 lord.
Page?
Page 194 your lord.
Yes.
That is clearly mentioned that lordship. Rule 6 sub rule 2 Sadar head assistant subdivisional head assistant by selection from amongst the senior assistant who at least 2 years of service as such to their credit, including supervisory assistant in concerned deputy commissioner establishment.
Huh.
So lordship, this criteria has not fulfilled by the respondent of 4 law.
She is not a senior assistant.
She
is a senior assistant before you.
but
Huh?
not supervisory assistant.
Only that much. Any other ground?
So even your lordship, although she was promulgated for the post of senior assistant lordship prior to appointed her
Prior to you.
prior to appointment for the post of senior assistant, her service was not confirmed, lords.
Where is that requirement of a confirmation? Show me the law of the confirmation.
So lordship, can you produce 11 lords?
Rule 11.
Rule 11 lords.
Hmm.
Suppose to rule 11 lordship.
Hmm.
So lordship, when however more than one person are appointed on the same date, their inter-se seniority shall be determined according to the position in their merit list prepared by the deputy commissioner as mentioned in notes below, clause 1 sub rule 5 rule 6. And subsection 6 your lordship can be produced lordship.
give confirmation of the member of the service. will
Mr.
get the rate.
Mr. Soikia, come to rule 9(3), sub rule 3 of rule 9, page 202. She was subsequently confirmed.
Yes, Lord.
Read that.
Rule
9(3). Page 202.
yes. Lord.
Read that.
If confirmation of member is delayed on account of his failure to qualify for such confirmation, he shall lose his position in their order of seniority vis-a-vis such of his junior as might be confirmed earlier than him. His seniority shall be however be resorted on his confirmation subsequently.
So confirmation is inglorious. What was that word used by Justice Iyer? Uncertainty. Supreme Court has dealt with this long back. Any other point?
But without confirmation of her services, she was communicated for the push of harassment.
Have you
That is
challenged
also
that?
violation.
Have you challenged that? It was given in that gradation list where regular circulated. You never made a challenge to that. She was promoted earlier than you. Did you make a challenge to that? You did not make a challenge. So today it's too late in the day. Any other point, Mr. Soike?
But your lordship, that is the basic criteria, lordship.
We'll
which is
consider
made by
that.
the Advertisement itself, that
We-
is also violated.
Advertisement says
You know,
confirmed.
this matter
Ad-
for fresh
ad-
consideration, my lord.
Advertisement says confirmation.
Yes, your
Where?
lordship.
Where does the advertisement require a confirmation?
So that is the advertisement itself, that is.
Mr. Soikia, do you get what I'm trying to put across? Where is the requirement in the advertisement that there has to be a confirmation? Or any person promoted to SA without confirmation as LDA will not be eligible. Show me that. Anything more?
Nothing, only this. But your lordship, the basic criteria has also been violated. That is the
Okay.
advertisement
You are
itself.
now a supervising assistant. You have been
Yes.
promoted subsequently. Subsequently, you have been promoted.
Yes, subsequently, I agree.
Very good. Yes, Mr. Doctor, anything to say?
No, I'm for respondent 4.
Okay. Done? Done? Anything more? Satisfied?
That is.
Satisfied? Your smile says everything. Disposed of. Hey, itu loi lo, okay? 9 to loi lo. 9 to loi.
In item number 9, I have filed an IA for vacating the interim order, my lord.
We'll consider the whole matter.
Yes, that is what this honorable court in its order dated 18/11/24 directed. And on 26/11, when this matter no, my lord, on 6/11, on 18/11, the matter could not be taken up as my senior was on another
6/11.
6/11, and on 18/11, when the matter was called up, my senior was on legs in another court. So I pray the matter may be taken up today.
Before I hear Mr. Chaudhary, today we are looking back. We have the benefit of insight of a division bench order, of which one I was also party. Now, the tender was floated.
My lord.
Mr. Chaudhary, just getting a clarification. Tender was floated. He was given a relaxed criteria of 59 days because he opted for that.
My lord.
90 days is the time.
No.
60 days.
60 days is the time, or 90 days, whatever it is. There was a time, there was around 7 people who quoted the same rate. You chose Mr. Chaudhary because
He gave the minimum number of
minimum
days to
59
mobilize.
days. So Mr. Chaudhary misrepresented. Let's hold it.
My lord.
Misrepresented.
Yes.
But Mr. Chaudhary could not mobilize the vehicle within 59 days.
Yes.
You gave him enough letters.
My lord.
Now, parallel to this, there was a proceeding before this court,
Yes.
wherein the entire, rightly, wrongly, the entire tender was under challenge.
A particular clause.
Be that as it,
My
the
lord.
tender,
My lord.
and that tender was set aside
My lord.
by this court,
Yes.
right? So any contract which was entered into under that tender, will it survive? That is the first question. One, let us say there was a contract between you.
My lord,
Mr. Chakraborty, I am not completed. Now, 4 people out of that who were allotted work along with Mr. Chaudhary goes up before the division bench. You have not challenged that.
no, my lord.
You have not challenged that before the division. You have accepted that. Now, 4 persons go before the division bench. And the division bench's order is very specific that the NOA,
NOA.
Notice of award.
notice of award, only in respect of that 4 will be maintained. Others you can go for fresh advertisement.
That,
Now, where does the contract entered with Mr. Chaudhary sustain?
no, my lord.
You satisfy me, then we will ask Mr.
My
Chaudhary.
lord, the NOA which was issued to the writ petitioner was cancelled on 16/1/2024. My lord.
Mr. Chakraborty, that entire tender on the basis of which can that contract say today? We'll pose a hypothetical question. Say Mr. Chaudhary has undertaken that work.
My lord,
Undertaken that work
my lord.
properly, 59 days. The court interferes with the tender notice. Will that allotment made with Mr. Chaudhary? Mr. Chaudhary is very lazy. He has not come to court. Will that survive? You
Because-
answer that, I'll go against Mr. Chaudhary.
My lord will appreciate the order passed by the division bench where your lordship was also a part.
That is why I'm saying. I'm
In that
emboldened by that.
order, the whole reason for allowing those allotted persons was that they were not made a party.
Be that as it may. Tomorrow, if the division bench interferes with the order of the learned single judge, then everything under that contract will revive. And if it revives, the allegation against Mr. Chaudhary will also revive.
Now the
We'll
question,
provide for them.
my lord, the question is on the day on which the honorable single judge has passed that order, whether the contract with Mr. Chaudhary's client was subsisting, because
Okay.
on that day, on 16/1, that is the order was passed on, my lord. I'll take your lordship to those facts. The single judge's order was
You have
passed.
got my query?
Yes, my
Now
lord.
just satisfy me.
Now, my lord, there are certain factual positions.
Hmm.
NOA was awarded on 4/10/23,
Give me the date of the
tender. Tender, last date of submission of tender was 6/3/23. Tender was opened on 6/3/23 and NOA was issued to the writ petitioner on 4/10/23. Now, the petitioner was selected. He was among 7 or 8 other persons submitting the same bid. And as per the bid tiebreaker, he was given the contract because he
59
had
days.
given lesser number of days to mobilize.
Okay.
Now, NOA was very categorical.
Hmm.
Lordship may have a look at the NOA.
We have seen it. You can
The
proceed.
NOA says that it should have been, he should have supplied the tender
Vehicle
within
complete in-
59 days,
Complete in all respects.
my lord.
He did not.
And the date of last submission was within which he ought to have supplied is 2/12/23. My lord, he files a representation or he submits a mail on 28/11/23 that the vehicle is ready for inspection.
Hmm.
That aspect has not been highlighted in the writ petition. On 28/11/23, he submits sends a mail that you come and inspect the vehicle. It will be placed on 29/11. On 29/11, 30/11, people waited for him, but
He did not turn.
it did not turn up.
That you have highlighted in your petition.
And on 1/12, he writes a letter for extension, which was rejected. Now, his entire case is that firstly, on the 4/10, there was a stay order. So this issuance of NIT is wrong.
That we will not go into.
It is a whole case.
We are not going into that.
Now, my lord, he was given the time,
When was the decision of the learned single judge?
my lord.
Final decision, 410 is the interim order.
26.
Hmm?
20th of June.
So here the entire tender, you have the order on record,
Of
the learned single judge?
Yes,
which was gone up on appeal.
yes, that
Where
has
is
gone
that?
up on appeal.
Petition it is there,
Yes, yes.
page 271. And operative portion is at 275.
Now, my lord, on 2/12/23, his 59 days was over. And and his agreement was cancelled
This
on,
is also with regard to Sipsagar,
my lord,
Sipsagar.
Yes.
yes,
And when was this cancelled?
16/1/23/24.
So when the matter was pending before the learned single judge, it was a fact that an NOA was already issued to the petitioner here.
Petitioner and some other person.
Forget it. To the petitioner, at least it was issued.
Yes.
So why was that aspect not brought before the notice of this court?
My lord. we
Because the
have-
order does not reflect that.
But there was subsequent clarification which we have placed, my lord, in the,
Where?
my lord, in the IA.
Okay. So this order,
You may come to page 34.
this order, as far as the appellants before the tribunal, before the division bench and Mr. Chaudhary's client is concerned, are at the same footing.
Yes,
It was never brought to the notice of this court,
no one.
coordinate bench of this court, that they were given an NOA. Okay, then
And my lord may have a look at a clarificatory order that was passed on in the writ petition, which
Page-
your lordship will find at page 34. Now, the third part, without going into determining as to whether the work order is issued, we clarify our interim order dated so that the expression shall not undertake any further process means that if the work order was not issued as on 4/10, the same shall not be issued, and if issued, that shall not be acted upon. We also clarify that the interim order dated 4/10/23 shall be in respect of only those tenders where the petitioner has participated. So the petitioner in that writ petition participated in two bids.
is it also a bid, including the bid submitted by the petitioner hearing?
That aspect is not.
Get that, that is it. If that
No.
is so, why should we proceed further?
Now, the question is, my lord, the petitioner
Mr. Chakraborty, you get that clarification as to whether I was on a general thing,
my lord,
division bench. Now there is a specific thing that if wherever the petitioner has participated, the interim order means not to issue,
or if
if issued, not to act.
my lord,
So clarify
Yes,
before we
that-
proceed further.
that I will clarify, but the thing is, my lord, it is
Mr.
never
Chaudhary, what
the,
is the position, Mr. Dhingia?
my lord, the petitioner's whole case is,
Others are operating, my lord, I am not operating.
No. With regard to this issue at page 34,
Huh.
we also
Oh,
clarified
with-
that shall be in
Shall
respect
be
of only
those tenders where petitioner has participated.
participated.
আমি কোট কোট participate করেছি? Oh, my lord, we are not the petitioner there. There,
I know
one
that.
Mahmood Ali was there.
Mahmood Ali was participated in the bid wherein you have been awarded in NOA.
It is
Yes.
Nibar. জানো না স্যার?
now,
I think we'll have to take that clarification.
my lord,
Because if that is there, then that is the end of the matter.
Yes.
now, the petitioner, the writ petition was filed by somebody. And the petitioner having failed to act upon.
Mr. Chaudhary is the common factor in two, but both are different.
No. Different, but in that writ petition, he is in fact challenging the allotment of NOA to this
Fine.
petitioner.
This has come up subsequently, not with at that point of time.
So, there was an order of.
Mr. Chakraborty, even when we were considering the matter in the division bench, why was the ONGC incapacitated to such extent? I'm using a polite word, incapacitated to such extent that it could not place before the court that, see, these are the persons to whom we have issued NOA. When the hearing, because NOAs were issued
Yes,
on the date when the matter was taken up for final consideration.
But the
Uncalled
thing is, my lord will appreciate one thing. Now,
We'll have it at 2, you get that
it
clarification.
will be difficult, my lord.
Right?
At 2, it will be difficult because
You
there-
just make a phone call only on that. Whether Mahmoud Ali had participated in a tender wherein Mr. Chaudhary is now agitating. Mr. Dhingya can also get that instruction. We'll have it at 2. You get that instruction. We'll finish it up then.
Instead of 2 o'clock, can it be Friday?
Friday, I have some difficulty.
Thursday?
Thursday.
Yes, Thursday.
Thursday. The only thing, my lord, what I understand.
Mr. Chaudhary,
Also have
Mr. Chaudhary, if it comes around that there is an issue which would also touch upon the judgment passed by the coordinate bench.
Yes,
Now an appeal is already pending.
pending.
You can make a request before the appellate court to have this matter also there
Along with
and
that.
then consider.
Yes.
Provided subject to the fact clarification of this interim order. Otherwise, it will touch on
And,
a order passed by a coordinate bench.
and another thing which I'd like to place before lordship is that on 16/1/24, when the tender or his contract was terminated, he did not approach, he was satisfied. It is only after the judgment in the writ petition. he spoke up,
Mr.
my lord.
Chakraborty, now what you want from him? You want the security deposit forfeited?
No, here it is a case where we have passed an order which is consequence to the termination order.
Okay.
Which says, no, it
Black-
is not blacklisted. We have not yet
Debarred.
blacklisted. We are passed an order saying that we are in the process of making an inquiry where we'll find out everything. And if the inquiry is against you, then the things will follow. But pending inquiry, it is permissible under the contract, under the general clauses, general conditions of contract,
can-
which he has unequivocally accepted it at the time of submission of the.
So for you, it is a fact that the matter requires to be heard at the earliest because otherwise the petitioner would be participating in similar
Yes.
tenders which would be issued.
And
Fine.
my lord,
Then it is more the reason that you get the information before 1 o'clock.
it will be difficult, my lord. Can it be taken up on Thursday?
Thursday, fine.
Yes.
Otherwise, my lord, getting instruction over telephone, someone will give and then the court may
Okay,
say
okay, we
something.
understand.
I don't want to take
No,
that.
we have faced that situation.
It's very difficult, my lord.
But there are also officers whom I have come across. A telephonic instruction was given. Before I reached my house, my wife had a letter delivered to her wherein the same thing was reiterated.
So, my lord, without taking any
That-
chance,
Huh?
It all
Depends. And
Without
I
taking-
have had,
without taking any
when I
chance,
was
my lord.
appearing this side, I have had persons like that.
So, it is
Telephonic
better
instruction given to the court. But
we-
before I reached my house, the instruction was there.
Definitely, ONGC will provide me the instruction, but
Just have
difficult at 2, it is difficult.
I only want 2 clarifications. One, whether after interference of by the learned single judge with the NIT and the stipulations made in the penalty, last paragraph of the order.
Clarifying that.
No,
Okay, my-
clarification comes subsequently. That everything gone, you will have to go for afresh,
Yes,
whether this contract will survive. 1. 2, the clarificatory order says wherever Muhammad Ali has appeared, means if you have issued NAO also, don't act.
now the question, my lord, if in terms of the single judge's order, if all the NOA goes, then my lord the division bench has allowed the other to continue. There is an order
Division
of the
bench has
division
the
bench.
power.
That is why,
But again, that is a stay order.
that is why that
The
division bench
judgment is
where your
not wiped
lordship
out.
is also a,
Mr. Chakraborty, it is only with regard to those 4
yes.
that
So, if-
this court
That-
has the
that-
power. How can you denude this court of that power?
No, I'm not that. Now the question is the petitioner, the writ petitioner, having failed to comply with a part of his.
Maybe I'm a bit slow in understanding, but
After
this
having
proposition of
completed-
yours I have not been able to understand.
My lord,
Because
after-
from yesterday I was having this query, that's why I did not even ask Mr. Chaudhary. I wanted it a clarification
So that
from
is
you.
the position, my lord. And
I'm
my
wrong,
lord, the-
maybe.
The single judge.
But I'll give let me pass a wrong order. Let
Let
me pass a wrong order. You have an opportunity, then go to the division bench to have an early resolution of the matter.
The thing is, my lord, the
Thursday.
petitioner was
Thursday.
aware of everything, my lord. He waited, termination order was passed,
We
he
can't
waited for the.
impute motive to the petitioner. He is a businessman. he will take all the pleas required to protect his interest.
And it is not even his case.
And
that
it is permissible for
now
him to
if
take it.
He was so much,
Mr. Chakravarti, it is permissible for him to take it because a writ court has passed an order in that matter, wherein the tender has been interfered with.
now that was passed subsequent to the termination order. On the day on which the termination order was passed, this contract was subsisting. And he prayed for time to comply with the order. Even on 16-1, the 90 days period.
That is why, Mr. Chakravarti, I asked you. Say Mr. Chaudhary was prompt, doing everything, but he is lazy, he is not coming to court. If this court had interfered with the tender, would not it have a consequent effect, also terminating the contract entered into with Mr. Chaudhary? Your answer cannot be no. If that be so, why not from this angle?
They are conveniently ignoring me, Lord.
You go up on appeal. Why have you not gone up and appeal against that order? You should have gone up on appeal.
That, of course, very difficult. It is already-
Calculations,
that is already an appeal.
decisions.
It is an appeal.
It's not an appeal by you.
Yes.
It's not an appeal by you. It's appeal by somebody else. ONGC is satisfied with everything. Now you want to?
No, but that-
fresh tender,
No, I've
And-
heard it.
And my lord, the decision was taken prior to the passing of the single judge's order.
Thursday, you get me these instructions. And if not only that clarificatory order, I want a submission from you with regard to the effect of setting aside of the tender on the contracts already in.
Supplementary post this, Administration Act 34.
Lordship,
Hmm.
I'm praying for some time to file an affidavit. Lord.
No, no, madam, regarding that direct equipment and ad hoc regulation.
Oh, prayer.
Doctor asked question to whether it is permissible or not. That is.
The Lordship, there is an issue here because.
What is the issue?
The issue is, Lordship, that cabinet approval has happened prior to that. There was a cabinet approval has prior to that.
Show
but
me.
the Only thing is that like communicating the thing.
Well, forget it. Show me the law which says that 3F period can be counted to
Yes.
what seniority.
No, 3F period does not count it. 3F period does not count it,
Show me,
Lordship. No,
show me.
Lordship, no,
Show me the cabinet
No, no.
memorandum.
Lordship, only the, Lordship, that's why. Lordship.
Page 105.
Just for number 3. Well,
105.
Difficulty.
Regularization of
105.
3F of AP.
This is approved. And
This is when?
12-6, if my lord looks at the signature below. Under Secretary to the Government of Assam, signed 12-6-2003.
Cabinet approval was done prior to that, Lordship.
It
Will
is the
come,
approval.
Lordship will. file
Where
an
is the
affidavit.
order?
Will file an affidavit, Lordship.
Where is the order?
Which order, Lordship, is making?
Order.
Communicating this.
Communicating.
That is on 29th of September.
Hmm?
Communicating this is on 29th of September.
Why? Why?
Lordship, that.
I'll tell you why. You have the cabinet decision is of 12-6.
Yes.
That is not final. There is a processing left.
The
The processing is it has to go to APSC. It has to get the approval of the
No, it has to get approval of the.
personnel.
SLC, Lordship, SLC
Ah.
approval was required. That is true, Lordship. But
That
But
approval,
regularization was done on the basis of the cabinet approval.
maybe.
Cabinet approval.
maybe.
Lordship, kindly give me some time to file an affidavit, Lordship.
I don't think so, Mr. This matter is pending, 23.
Just give me a 1 week, Lordship, it's already ready and it has gone for vetting, Lordship. 1 week's time, I require to file an affidavit.
Where is
to
that
bring this
order
forward.
of their regularization? Communication? It's not communication, it's an order regularizing them. Where is that?
That is there in page.
Yes, Mr. Ahmed, where is it?
Yes, I'm,
101 of
page
my
47,
Huh?
page 47,
42,
47.
47.
In the interest of public service, Governor Assam please to regulate the appointment of three overseers, namely Bhairav Kumar Nath, Apurva Kumar Kolikar,
Ah, this is the order which gives them the retrospectivity from
Yes.
12/6.
For the date of approval of by the cabinet.
And the SLC approval came only on 9/9.
How many days? Approval.
Mr. Kolita,
Lordship.
there is nothing here. You are the employer, you be happy. Whoever is there is there.
The Lordship, only thing is the Lordship affidavit is already ready, Lordship. Just give me 1 week's time so that I can file it, Lordship. Bring up a record.
That is why we gave you time on 22/11.
When I could not go through it, there is a death in my family. I could not go through the file. I also want to consider. the
After
law.
that, I can't say anything. On the prayer made by the Learned Council for the respondents, registry to list this matter again on (17, 12, 2024) or 17, 12, 2024. Also, the respondents are at liberty to file their affidavits, respective affidavits, comma, if not so filed, on or before 11, 12, 2024. List this, registry to list this matter again on 17, 12, 2024 for further hearing.
Obliged, Lordship.
But Mr. Kulta,
We'll
much.
we'll look into it, Lordship.
it's too much.
We'll look into it.
May please, Your Lordship.
Hmm.
May please, Your Lordship. Lordship, the petitioner has been working as an Anganwadi worker. Lordship. He has been terminated from his job without being at.
What is the error in that order?
Yes, Lordship. Lordship, the error is that, Lordship. When she has been terminated from his service, Lordship, the inquiry that has been submitted to the additional district judge, that has been not submitted to the petitioner. That is the point, Lordship. The unfair and injustice inquiry has been done in her back.
Okay,
Yes,
the
Lordship.
inquiry report is on record.
Yes.
Where?
It is
Page?
not in record, only affidavit in opposition that has been in record, Lordship. And
Affidavit in
the-
opposition, it has been brought on record.
Yes, Lord.
Page? Forty.
40, Lord.
Okay. You now
Yes, Lord.
argue on this.
Yes.
You satisfy me as to why this is done.
Sit.
You have not filed a reply also
I have filed, Lordship.
here
Yes, Lord. Today I have filed.
today.
Yes, Lord. Actually, some defective is there, Lordship. Today is clear, Lord.
We have not received any copy.
That is the acknowledgement, Lordship. We have filed it.
You have a copy?
Yes, Lordship. That is. I have submitted the copy in an earlier date, Lordship.
Reply copy?
Yes, Lord.
Okay. Yes, where is your statement?
Lordship, in this case, Lordship,
Now I want you to, where is your reply
yes, Lordship.
to the issues that have been raised in page 40?
Lordship, only have the so-called reply, Lordship.
No, in your reply, in your this reply,
Yes, Lord.
where have you dealt with page 40? You say that is the inquiry report.
Yes, Lord.
Where have you dealt with it? You have not even referred to that. You have reiterated only 9. Rule 9, 1964. You had an opportunity. You
Lordship,
could have brought before me that, see, these are the grounds taken, these are perverse for this reason, or these are not sustainable for this reason. Enough. We will have adjudicated. You have failed.
Actually, what happened, Lordship, in respect of the Rule 9, Lordship.
Rule 9, forget it. You have the inquiry report now.
Yes,
Some factors have come. What is your reply? Your case was Rule 9, the inquiry report was not given to me. So it is bad.
Yes, Lord.
But the inquiry report is before you today.
Yes,
It was there. This affidavit was filed on 8/11/2023, even before I became a judge,
Yes, yes.
right? So it's around 1 year now. Why have you not dealt with this? They have made categorical allegations there.
Lordship, I may be allowed to file an additional affidavit stating that.
Yes, Mr. Bora.
Your lordship ruled.
He may not know that procedure. So he made a, let him take steps what he want to
Let
do.
him reply.
Reply. Heard the Learned Council of the parties, Learned Council for the parties, the Learned Council for the petitioner, Mr.
You, Sharma.
U. Sharma, submits that he be given a week's time to file an additional affidavit to deal with the report of the inquiry report of the CDPO, Lala ICDS project, Hailakandi. So, prayer accepted. The petitioner is permitted to file an additional affidavit in the matter as prayed for. Registry to list these matters again after 6 weeks on a date to be fixed by it. Subpara. The matter shall not be treated as a parted and or tied up matter any further.
36.
Same,
36.
Same.
same.
36 of same order. Here also there is a report.
Yes.
Yes, Lord. Yes, it is.
Where is that?
The affidavit, your lordship. Page 39, annexure B.
Test 40 lot in affidavit of origin.
Thereafter,
And okay. No. Page child development project officer Hailakandi, same. Beleg order might be.
37.
Oh, all of this mother.
38.
Yes, Mr. Ganguly, 5 years or 10 years?
Malod, 10 years. And Malod, my affidavit, Malod, it's ready, Malod, I'll
Okay.
serve it by this week.
Okay. Heard the Learned Council, Mr. R.K. Sharma, Learned Council for the petitioner, also heard Mr. A. Ganguly, Learned Council appearing for the respondent bank. Subpara, Mr. Ganguly submits that the affidavit on behalf of the respondents is ready and would be filed within a week. So accordingly, the registry to list these matters again after 4 weeks on a date to be fixed by it. So the petitioner is at liberty to bring on record the rejoinder, if so advised, against the affidavit to be filed by the respondent bank.
If
it is not inconvenient, can a date be given?
Date not given. Will give it.
39.
4 weeks will liquidation as prayed for by the registry to list this matter again after 4 weeks will liquidation. As prayed for by the Learned Council for the parties, registry to list this matter again on so and so.
39.
Yes.
Taken after some time.
Mr. How long will it take?
Well,
It'll take some time because I'm not here anywhere next. I don't want to make it partner. Not be here from next week.
Let come after vacation.
Okay. As prayed for by the Learned Council for the parties, registered to list these matters again.
After 3 weeks, my lord.
Huh?
After 3 weeks, I am taking some additional instructions.
Raise this matter 4th week of January on a date to be fixed by it.
Okay.
List this matter before any other bench without me. I'm there. Who is opposing you?
ONGC is the main losses. Only small issue of my PRC not being, that is the case. Only there is nomenclature of name. Nothing else. Permanent residency, everything is there.
Private response.
Private response.
ONGC. Who is there for ONGC? Who is there for ONGC? Mr. Barmiya? Who was appearing for ONGC?
Learned Senior Counsel Mr. G.N. Shaiwala lordship.
You are appearing.
I am for restaurant number 10.
He is private.
I file a video with my lord.
We here, but the ONGC is not here. What will you do?
Day after tomorrow, take our urgency is their losses because
I'm not
earlier
here.
round of litigation are disposed of, subsequently review petition.
Either today or next week.
Today,
Get hold of Mr. Saiwala.
yesterday called Mr. Anish Singh lordship. Mr. J. Shaiwala is not available for the day to
Okay.
accommodate him. That was
Why
their
didn't you tell me that
requested.
before?
Well, next week,
Uh,
any
Day after
Mr. Barmiya
tomorrow.
submits,
Tomorrow
that-
he is available.
Mr. Barmiya submits, heard the Learned Council for the parties. It is submitted at the bar that Mr. J.N. Saiwala, Learned Senior Counsel, appearing for the ONGC authorities on account of certain personal inconvenience is not available today. So accordingly, registered to list this matter again on
Short date. lordship.
4/12/2024.
Lordship, can it be third or fifth, lordship? On fourth, I have some possibility.
Then it will be 9th.
Actually,
Obliged.
fourth,
He has some difficulty.
but they are serving lordship, that's why difficult.
Why was your case then got to be dismissed for default? If that was the seriousness. So, Barmiya,
Obliged.
lesser you make me open my mouth, that is better. 9th.
Obliged.
I'm sorry.
14.
Who is appearing for the government here?
There is sending council secretary administrative.
None appears for the parties on call. However, for the ends of justice, registered to list this matter again after 4 weeks on a date to be fixed by it.
15.
Please come in.
Please, your lordship.
Oh.
This is a matter of pension, my lord. The petitioner, my lord.
Mahatma Gandhi Kashi Vidyapith.
Yes, my lord, he initially joined there, my lord. He came on lien, my lord, and finally retired from the Assam University. Now, my lord.
Now, who was bearing the pension contribution and leave salary contribution, pension contribution at that point of time?
My lord, well, Kashi, my lord.
Huh?
My lord, they were, my lord. Because they have, my lord, said that they are
willing to transfer everything, my lord, whatever required. That's they have stated in the affidavit. It's Assam University which is saying, my lord, that they have to do it. And my lord, they are willing to do it.
Wait. Came running.
Yes, ma'am.
Take a breath. We'll take it up after matter. 2 o'clock.
Lordship,
Sure.
in this case, I've talked to the registrar. Just
Huh.
they said that some development took place. Lordship may be taken on Friday.
No, that will not do. What is that development? In his favor?
Yeah, definitely in his.
I appear for the Mahatma Gandhi University.
Okay.
We have stated in our affidavit that whatever was with us, we have already transferred to
Transferred.
the university
Hmm.
and whatever else they require.
We are ready to
Whatever
give.
For them, we are ready, but that is given at.
I've seen it. But then why are you
Now
not
they need
taking
to
a
push.
call?
No, Lordship, that's why I'm awaiting his further instruction because we filed affidavit at that time. We didn't receive any document from them. Now after filing they said they sent some documents to the university.
Mr. S.C. Kyal, Learned Standing Council, Assam University, submits that the issue involved in the present proceedings pertaining to release of pension and pensionary benefits to the petitioner is under active consideration of the university authorities in consultation with the authorities of the Mahatma Gandhi Kashi Vidyapith. Full stop. Accordingly, he prays that the matter be taken up after 6 weeks so as to enable him to apprise this court about the development taking place in the matter. Full stop. Prayer is not objected to by Mr. M. Dr. Learned Counsel appearing for the petitioners. Full stop. Accordingly, registry to list these matters again after 6 weeks on a date to be fixed by.
Can I pray for date?
Accordingly, as agreed to by the Learned Counsel for the parties, registry to list this matter again on Seven, 1/2024.
Much of.
Hopefully, the new year will begin a new beginning.
He's without pension since 16 valid.
I have seen it. We would have proceeded.
Kindly pass over the matter for time being.
Why?
Dr. Senior Counsel say MK Chaudhary will appear in this matter.
Yes.
Senior is on legs.
Both of you having problems. 2 o'clock.
Okay.
18.
Lordship, on behalf of me, Google, may I pray for some accommodation today, Lordship? He had some difficulty. Otherwise, Lordship, he's working on the query that was posed to him, Lordship. He'll address
Thursday.
Lordship.
Thursday. He's having come.
Yeah.
He was in a marriage yesterday, so naturally he got delayed.
Latest judgment by Ujjwal Bhunya, SBA Naveen Kumar, delivered on 19 November, your lordship. So in this case, show cause was but no charge memo. Inquiry proceeding was initiated after retirement, your lordship.
That is on a different, this is Justice Oak's judgment. We have read it.
I marked the paragraph. 20.
My Lord, Justice Bhuya had delivered it.
Yes, yes.
But this is on a different point.
But here also, your lordship, only show cause, but thereafter no charge memo. nothing.
Mr. Majumdar, you have not understood. I am beyond that. If the inquiry officer comes up and reports, submits a report saying that we cannot establish anything in this
Yes.
matter, wait for this criminal case to be over, so that inquiry proceeding has to go. That's what I'm trying to say. Now, you are now on a different footing.
I am very much obliged, your lordship. Thursday it may be
Thursday.
final disposal,
Indeed.
for final disposal, your lord.
Ah.
Obliged, obliged.
1932.
But you can these matters be taken up at 2 PM also?
Why? There are many other advocates, Mr.
Is also my lord.
Huh?
Mr. S. Waterpur will also appear, my lord. So
Mr. Okay, fine. One is an association and the others are individuals,
Individual.
but they are the same, 741 or something.
Yes.
Now, these people all were engaged according to you, not following the procedure, were engaged at a particular date for a particular period. Thereafter, it was being extended.
That's some were extended, Lordship, but in other cases, no extension.
Extension.
Yes, they are just continuing.
Now, tell me one thing. We'll go into the merits. Now, what is the position of law with regard to a contractual employee where the extension order is not there? Can the court bring them back
No,
into service?
to that aspect, Lordship, one recent Supreme Court judgment is there.
Show me.
Today, I have not brought. Just
When will
Lordship-
you bring it? Today you have to
No,
bring it.
Lordship has raised this issue that.
Why? This is the issue.
Yes. But
In your
just-
favor.
Just because they are.
I always say something against you. So today I said I'll say something in your favor.
Yes, the Supreme Court judgment is.
You have a grievance to that. So I said I'll redress that grievance today. Gridco, following Gridco.
Not Gridco, Lordship, a very recent judgment.
Following Gridco, the law was there. What is that citation?
Citation I have to give, Lordship.
We'll have it at 2. You get that citation.
No,
If that
today-
is the position, we'll finish it up.
Today. The other parties.
Other party, they said 2 o'clock.
No, initially, though the grievance was against termination, Lordship. Now they have renewed their, prayer, Lordship. Renewed means it's some kind of modification. Now they are saying that instead of allowing others to join, Lordship, on same ad hoc post, Lordship, let them continue in those posts, Lordship. That is now their prayer, Lordship.
But make them also eligible if you allow, subject to what they say, tentative view. They'll also have to be made eligible in any subsequent recruitment exercise you take out.
That we are not denying. Any regular appointment.
But get me that decision. And Mr.
Possibly issue which we are saying is that they are trying.
No, I'm not on that. What I'm on is, if you're a contractual employee and there is no extension, can this court by its order extend your services? The orders that I have found, it says that we are not extending your services. So the thing comes to a close. Now, on the date you instituted this proceedings, there is no extension order. There is no service.
They are doing also.
Now, whether I can bring you back.
Contractual period. They cannot.
Madam, you're also here in this series. One query. All are contractual employees. You are being extended from time to time.
10 years now.
One point of time, you were not extended any further. Be that as it may, X, Y, Z, whatever reason. Now, can I bring you back in absence of an order of extension? If there was a period of service, you came in between, I could have allowed you to continue. Right? Now,
Lordship, we are the only ones who are continuing. I'm referring to 3 of them.
oh, you are continuing. So you will be in a different footing.
No, in one case, they are enjoying the status.
Oh,
I mean, pay.
then I have a power in their case. What will be happening to others? 2 o'clock. 2 o'clock. In my query is reverse your case. In your case, I would have the power because you're continuing.
Continuing because of the court's order.
Be that as it may.
Okay.
Today that by deemed thing that their service is extended. Deemed.
Otherwise, that decision for not extending any further is applicable to all of them.
We'll decide.
Lordship.
But her case will not be the answer. The others will have to satisfy me that I have the
Lordship,
power.
instead of today, Lordship, if possible, Lordship, if convenient to your Lordship, Lordship will take on another date, Lordship.
Want it on another date, all of you.
Yes, Lordship. Advocate General is also appearing this.
That is what it was stated in the very beginning.
No, I also did not read all the files. I read a few files only.
Basically, the association post.
Association case I have gone through. Mr. Kumar, Kumar is also not here.
Yes, sir.
Okay. When? You enjoy your continuation, ma'am. Why are you rushing along with them? No hurry for you. We'll take it up after the vacations. Right?
Lordship, can it be in the month of December? That's an urgency.
In the month of January, then, Lordship.
January. As prayed for by the Learned Council for the parties, registry to list this matter again.
December because we are
December. Okay. When? Give me a date.
any convenient date.
No, nothing convenient for me. You give me your convenience. Just leave the last week, it will be a motion day. Third, 10th, 5th, 12th.
Lordship, can we get back with the date with the court master? We'll just ask the council, Mr. Kuwar and Mr. Chaudhary also.
Date to
We'll
date.
inform him.
Kali last week or Nidibo.
In the first week of December, Lordship.
Next week.
January go. January go.
Okay, you give that. date. Next matter. Yes, ma'am. A date to Didi বনো। এই দুটা কিবা ডিসপোজ কৰিলো যে এই দুটা দিদি আছে।
matters for the records of
Yes,
occasion, Lordship, directed to bring records, Lordship.
Lordship, records are not necessary, otherwise it's only with regards to disproportionate and proportionality of punishment, Your Lordship. The issue is that only. Okay.
where is Mr. Kanangu? You are arguing on Mr. Kanangu? We'll have it at 2. Nothing is here. You argue. No records are required. Argue and thagi vision. It also.
On last occasion, Lordship, they submitted that
You want to do the matter?
yes, Lordship.
Then we'll have it at 2. If you don't want to do, I'll adjourn it. Then we'll have. So what are 2?
Lordship. Item number 14, I have missed this, Lordship, I apologize for that. Kindly be fixed at 2, item number 14.
I think we have adjourned the matter. You want to do it?
It's not, 17 is adjourned. Item number 14,
None appears, huh? At least after 4 weeks.
Lordship, my senior is his legs in another court, that's why
You want to do it?
senior will do it.
Who is your senior?
Mr. UK Goswami.
But Mr. UK Goswami, today, the whole day it was mentioned that he is not here. He wants to come, let him come. 2 o'clock, 2 hours. But there are other matters wherein he has taken adjournment on personal inconvenience. So those matters will also be listed.
Here, Your Lordship, he has to inform the standing council SAD.
Whoever it's, you have appoint, inform, bring them back. We'll have, we are here till 4:45. We are hearing.
Actually, he's out, another court in Amingaon. So that's why.
Oh. Then 4 weeks, after 4 weeks. How come you order?
Will come at 2 p.m.
It was right. It to more. A Bothakura Celtic. Yesterday night I went back again, I read 33 twice.
Your
But
Lordship is absolutely.
I could not find out any other meaning.
Absolutely right.
As a senior counsel, Mr. Chaudhary, as an amicus, you tell me, what should I do?
That is what, my lord, I am imploring that, my lord, my learned friend.
That you should have to go out. I also understand that lady now, maybe because of that, she is sustaining. Husband had gone,
Minor child.
minor child. When did you make your application?
My lord, the application was made
On 9/9/2013.
9th of September 2013.
Husband died on 19th of June 2013. She made the application on 9/9/2013.
No, husband died on 10/8/2013.
My lord.
Husband died on 10/8. Application is 9/7. 9/9.
9/9.
19/6. 19/6. 19/6 husband died.
The husband died on 19/6, my lord, 19th of June.
2013.
And within 3 months, my lord, she applied.
That date is also wrongly recorded here.
But the application, my lord, it says the husband died and the death.
If you come to page 33, last paragraph. Srimati Seema Dev, wife of late Ashutosh Dev, unit boy, who expired on 10/8/2023, 10/8/2013.
But in her application and the affidavit, my lord, she has said it correctly, my lord.
See the casualness. Yes, Mr. Bora. What is this?
I'm in a fix, Your Lordship.
No, I think you'll have to call. If you're in a fix, we'll have to call the senior government advocate. Because we can't ignore those things.
Should we take it up on Thursday? I'll inform you.
Because if he does not get a job, compensation adequate. Tell me what would be the adequate compensation. Because of this illegality, the respondent is earning a good sum. After the 7th pay commission, it has even gone up. So the whistleblower should also be compensated. I'll not call him a claimant. I'll call him a whistleblower. Just tell me how much compensation. If that amount is satisfactorily to my ears, I may even think of not proceeding against.
Lordship, let me consult with him. Okay.
Mr. Chaudhary,
Ma'am.
your submission accepted till Thursday. Provided the government compensates him adequately, we may even think of doing it. Otherwise, compassion is one thing, but such illegality coming to the notice, it's not, my feeling is not permitting me to proceed. That's why I've been delaying it, but I'll have to take a call. And I'll have to balance both. If it's a court of equity, I can't only look at the respondent, I'll have to look at the petitioner and the others in the fray who might have. We'll work out something on Thursday. And you address me. You tell me in such circumstances how this court, I'm asking you, frankly, how this court should proceed.
The one your lordship has suggested, my lord, the adequate compensation.
That is my suggestion. I want your suggestion on that.
I don't have any further submissions to make, my lord.
Thursday, as prayed for by Mr. D. Bora, learned counsel, learned government advocate, raised this matter again on Thursday. Mr. M.R. Adhikari and Mr. M.K. Chaudhary, learned senior counsel, appears for their respective parties. For their appearing for their respective parties are present. We'll see, Mr. Chaudhary.
May I please? Lordship, I want to withdraw this petition of the Lord.
The ROP is here. Why are you withdrawing?
For instruction of our client, my lord.
Instruction of your client. Or demand. Your name?
I.H. Khan.
Item number kiman itu?
3.
Mr. I.H. Khan, learned counsel for the petitioner on instruction submit that he be permitted to withdraw the present writ petition. Full stop. Prayer is not objected to by Mr. D. Bora, learned counsel, learned government advocate appearing for the respondents. Accordingly, the writ petition stands dismissed on withdrawal.
That liberty.
No liberty. You argued. You argue, I'm ready. We had only asked Mr. Mondal that I want the ROP rules. That ROP rules is here. Before I could even look, you want to withdraw. Withdraw. It's your liberty. No liberty. No liberty given. Liberty. Yes, Mr. Chaudhary.
Manoj, I must fairly inform this honorable court, Manoj. I got to received a call from Mr. Borpujari saying that they had misplaced the file, Manoj. Then they were not in a position to make submissions today, Manoj. I said, Manoj, if the matter is
You can communicate back to Mr. Borpujari that we have not accepted that. You can continue. Because they are not refret of advocates. Somebody could have come here.
yes,
If I require some instructions, they could have furnished that.
I was informed they had misplaced the file. Manoj.
Okay, fine. They could have told that to the court also. Maybe I require some instruction, I can ask it. Now you argue, we will consider.
Now, the petitioner, Manoj, was working as an audit officer, local fund, under the additional director, local fund, Sagar Manoj. He was arrested on 28th March 2021, 2001, in connection with Sipsagar PS case number 79 of 2021 on charges of having received illegal gratifications. He was enlarged on bail on 10th April 2001 thereafter. There is a notification thereafter, my lords, of 28th March 2001, my lords, whereby he is deemed to be on.
Yes, ma'am, you are paying.
AG Lordship.
Wait.
7.
Then what happened?
My lords, he was placed under suspension, my lords, by the notification of 27 June 2001. And he was deemed to be under suspension with effect from 28/3/2001, which is the date of his arrest, my lords. Now, my lords, thereafter, departmental proceeding was drawn up against him on 4th September 2001, my lords. A state inquiry officer was appointed by the notification of 28th of May 2002. Now, these facts are reflected in the inquiry report, my lords. Now, the charges framed against the petitioners are threefold, my lords.
Where are the charges?
Yes. Now, if my lord takes up the inquiry report, it starts at page 38, my lords.
Show cause is not here.
Show cause is not here. This is the inquiry report, my lord. The description of the charge number 1, my lord, is at page 40. That while the delinquent officer was serving as audit officer local fund in the office of the assistant director of audit local fund, he was deputed to check the area nil bills of the office of the block elementary education officer, Amguri Nazira block under education department in Sipsagar district for a period from 1/1/1996 to 31/07/1998. In course of checking the bills in the office of the deputy commissioner Sipsagar in room number 27, the delinquent officer had accepted illegal gratification of ₹1,000 from one so and so at around 3:30 PM on 28/3/2001, who had been deputed by so and so to be present at the time of checking of bill. A case bearing number 79/2001 under section 161 IPC against the delinquent officer was also registered in the police station subsidiary. The delinquent officer is therefore charged with receiving illegal gratification, doubtful integrity, misconduct while discharging his official duties, violating the provisions of the Assam Civil Services Conduct Rules 1965, my lords. Now, the second charge, my lords, is at page 42. Description of the charge is at page 42, my lord. The charge, in a nutshell, it's with regard to irresponsibility, misconduct, and attempting to mislead the government while discharging his official duties with high responsibility. Now, my lord, the allegation as far as the charge number 2 is concerned is that he had not informed.
When was he arrested?
He was arrested on 28th March 2001.
And he remained in custody till 10/4.
10/4/2001. And the third charge, my lords, is at page 44,
Okay, 29-3-2474, by he submitted casual application.
casual application.
Why? From jail.
Now, that is their allegation, my lords.
You have not submitted.
Well, respectfully, my lords, petitioner, these applications I have taken instructions from, he said that these applications were not casual applications, but these were applications that he had submitted after he had come out from the jail, and said that this period I could not have possibly informed you about my incarceration because I was.
For that, he need not submit backdated applications. And he is an audit officer. He knows the rules very well. So charge number 2, you have nothing to say.
Yes.
Charge number 3?
Charge number 3 is, my lords, it starts at page 43, my lords. The delinquent officer was therefore charged with insubordination, unbecoming of.
Okay, what is the penalty?
Yes. Now, no penalty has been imposed, my lords. What they've done, my lords, there is an inquiry report of 15 September 2012.
Where is that?
The very report that was.
Okay, fine.
Now, this was forwarded to the petitioner, my lords,
Hmm.
on 22nd August 2013. That is the admitted position, my lords.
2013.
Inquiry report is of 15 September 2012. The report was furnished to the petitioner on 22nd August 2013. He was asked to provide his comments on the inquiry report. Now, my lords, at para 9 of the writ petition, para 9 and 10, in fact, my lords, if I may just read that, my lords, that the petitioner states that the following, the submission of the inquiry report dated 15 September 2012. The respondent authorities serve a copy of the said report to the petitioner on 22nd August 2013 and sought comments from the petitioner as regards the inquiry report. The petitioner accordingly submitted his comments by the communication of 14/10/2013. But why I'm reading this is important because, my lord, they have not disputed this in their affidavit, my lords.
Okay, that matter.
Yes. Thereafter, my lords, at para 10, that the petitioner states that the respondent's authorities, after the receipt of the letter dated 14/10, failed to respond.
Is
to
there
the
a stay order in this proceeding?
Yes, no, there is a status quo order with regard to the DP.
We'll have to vacate that.
My lords, my submission would be, my lords, the very protracted nature of the departmental.
It's
proceeding.
not nothing protracted.
My lords, because subject.
You
to-
got it? Where is that paragraph that you're trying to read?
My lords,
Para?
that paragraph with regard.
That paragraph with regard to the inquiry report.
Yes, my lord.
Para?
Their affidavit, my lord.
No, your affidavit.
My petition, my lords.
Ah.
Para 9 and 10, at page 9.
Where is your representation dated? 14/10/2023.
I must be failed, my lord. It's not on record, my lord. They've
Okay,
not
how-
disputed it, my lords.
Okay.
They've not disputed this in their.
Respectfully submits that the following the submission of the inquiry, the response is so and so, so and so. So and so, so and so, so and so. Following the decision are not contacting them. Okay, what is this communication of 22?
22/8 is the letter by which the inquiry report was forwarded to the petitioner. my lord.
Not on that, not on that. With regard to page 57.
Page 57 is my representation, my lords.
Assam pension rules too. Now, why did you submit this 412? If you have already submitted way back in 2013, a
Yes,
representation.
because my lord, the prayer in the representation is not only with regard to commenting on the charges or the allegations contained in the inquiry report. There's also a prayer for releasing the pension, my lord. Petitioner retired on 31st
No,
January.
here there is no pension. Page 57 to 59.
Page 57, my lords.
Hmm.
My lords, the second paragraph, my lords.
I've seen it, but
I've
what
not
prompted you? What prompted you to make this?
My lords, because I've submitted my representations, there are many sub representations even after that, my lords. There is one at page 55 also, my lords. There is a prayer for fixation and issuance of the pension order.
So the penalty that can now be issued to you is under 21.
If at all, my lords, penalty.
The show cause is not on record.
No.
Why?
Lords, we did not have all the documents, my lords.
Why?
Or the petitioner did not have all the documents.
Where did it go?
We apparently misplaced them, my lords, but they are not on record, my lords.
So we'll have to rely on this. Mr. Chaudhary, why are you arguing all these things? Any proceeding that is now against you is under 21,
21, my lords.
right? This proceeding gets converted to a 21 proceeding.
20.
Have you read 21?
Yes, my lord. The power rests with the governor, my lords,
To what extent?
to interfere or pass an order interfering with his pensionary benefits, my lord.
Under what circumstance?
Found guilty of grave misconduct negligence during his period of service, my lords.
Prepare well, you have not prepared. Read 21 once again. Here it's only withholding of pension,
Yes, my
right?
lord. Yes.
When can the pension be withheld? Read. The governor reserves so and so to permanently or for
Whether-
recovery from a pension of the whole or part of any pecuniary
If a departmental or judicial proceeding, the pension.
of, you're missing out the main line.
Yes, ma'am. Of the
Right
whole
of
or-
ordering the recovery from a pension of the whole
Yes, ma'am.
or part
Part
of any pecuniary loss caused to
of
the
the-
government. Where is that
Where is the law?
pecuniary
Where
loss?
is the law?
Yes, Mr. Prabhujari.
Today I am handicapped, my lord. I have misplaced the file.
We'll
But I have
handle
taken
it.
his
But I did
pension.
not know that you could send a message to the petitioner's counsel
No, my
that the
lord,
file has been misplaced.
my lord, I beg apology. In the morning, my lord, I had called him up. My lord, that let me mention the matter at the mention hour. He requested me to wait till the matter reaches.
Okay.
So therefore that.
I was given the impression that maybe you have asked him that you have missed the file, so you want an adjournment. That was maybe I got an impression like that. Anyway,
Lordship, can it be after 2 weeks, my lord?
Okay,
Because my lord, in the meantime, some,
but this will not survive in view of 21.
I will try to persuade my lord. And in the meantime,
But
my lord,
Mr. B. Chaudhary, Lanark
some
Council for
subsequent
Deputy.
development has also taken
Mr.
place.
B. Chaudhary, Lanark Council for the Petitioner, also heard Mr. R. Bapujari, Lanark Standing Council, Finance Department.
For R1 entry.
R1, 2, and 3. Mr. Bapujari submits that the file has been misplaced and accordingly prays for an accommodation in the matter. Full stop. The full stop. Prayer accepted. The submission of Mr. Bapujari is accepted. Registry to list these matters after 6 weeks on a date to be fixed by it.
And so, in the meantime, some subsequent development has taken place. I will apprise, my lord.
Nothing will take place. Now, if you have taken place also, it will go. Now you have understood the purport of.
Subject to what lordship said, the difficulty I'm facing, my lords, the petitioner's wife, my lords, is critically ill, my lords. They're facing a lot of difficulty.
After a week.
My lords.
Can it be 2 weeks, my lord? With
Week.
all respect.
Wife is
I'll give him the
critically ill.
copies. I'll give him the copies. my lords.
You give him the copies.
Yes, ma'am.
Mr. Bapujari will take 5 minutes. Date Didier. First time. Side right. Side right. 412.
Can it be, my lord, after 6th of December, any date, my lord? It can be
9th. 9th.
9th. My lord, I'm so obliged, my lord. I'm so obliged.
Sorry, Lordship, I was not in time, Lordship.
No, it's okay.
It's regarding morality of the retirement benefits, my lord.
Yes.
That will go to the.
Lordship, I have filed a affidavit in opposition, Lordship.
Para 19,
Para 19, page number 38, Lordship.
It admitted the amount is due.
Yes. When are you paying him?
This is entitled amount, Lordship, due to acute financial condition. Lordship,
Sell your flats. Sell it, pay him. He's more needy.
We will pay.
When? 1 week, 1 month?
We are not denied, yes, so.
You have
Lordship,
filed this.
total-
When did you retire?
Entitled.
Retired on 29 to 24.
29/2. How much you have been paid?
Paid, what is in paragraph 19 is that 17,31,000 is due, at 20 rupees due. He is saying in by this November, he is paying 5,31,020 rupees. And rest in 1 lakh rupees in 12-month installment. Only there are other orders, my lord. There are similar orders, my lord.
Why are you not paying him?
Lordship, acute financial condition, so that's why. Lordship, we are
Well,
not denying to.
You have undertaken to pay it in a particular manner in para 19. Why is that not being complied with?
It will comply, Lordship.
No. 19.
Lordship.
Who has sworn this affidavit?
Lordship.
Commissioner.
Lordship.
How can he go beyond this now? Why in the month of November, 5 lakhs?
It will comply, Lordship.
No. November is over.
No, Lordship, matter was not listed, that's why.
Need not be. You have filed an affidavit. You have stated on oath that you will be paying 5 lakhs within November.
Because the matter is pending before this honorable court, Lordship.
That is why. Okay.
That's why, Lordship.
Lekha. That is why you are not paying. We'll clarify. Heard Mr. S. Bora, Lanark Council for the petitioner, also heard Mr.
T.R. Gogoi, Lordship.
D.R. Gogoi, Lanark Council, DR.
T.R.
T.R. Gogoi, Lanark Council for the respondent. Mr. Bora, by referring to the contentions made by the respondents in para 19 of the affidavit filed in the matter, has submitted that the respondents had undertaken therein to pay an amount of rupees 5,31,020 to the petitioner within the month of November 2024 out of the entitled dues receivable by the petitioner on account of pensionary retirement benefits of rupees 17,31,020. Full stop. It is submitted that the said amount has not been credited to the account of the petitioner even till date. Full stop. Mr. T.R. Gogoi submits that the said amount has not been so credited only on account of the pendency of the present proceedings. Full stop. In that view of the matter, it is directed that the respondent 1, 2, and 3
Lordship.
shall release the said amount of rupees 5,31,020 within Thursday date to the day. Registry to list this matter again on Friday.
Lordship.
Release that money, 5 lakhs. We'll see if what can be done thereafter.
There are many similar orders with 7% interest.
That we'll give you. Don't worry.
Not the entitled amount is, we have to.
If you have calculated, you have said you are paying,
Lordship.
pay him, because you said because of the court proceedings you are not paying. I've clarified that.
Matter
So
of-
5 lakhs, pay by Thursday. Friday, we will have the matter listed. If not paid, we will take whatever is to be done.
Lordship.
On 29.
Or you have some other submission. I have only followed your submission.
Lordship, that is correct, Lordship.
You
We have-
said 2 things. This is an entitled due, we will pay.
Yes,
We have not paid because the matter was not listed.
Lordship.
So we have clarified. Paying by Thursday.
On 29th, lawsuit. 29th, lawsuit.
29.
Lordship.
Pay by 28.
Lordship, can it be 30, Lordship? Please, Lordship.
30 is the bill. Oh, Saturday only.
Okay. 30th we will come.
Lordship.
30th, court is open.
Court is
Saturday,
open.
madam. 30.
No, sorry, Lordship, sorry, Lordship.
Let it be
Lordship.
on 29, let's see the.
Court will even close.
29.
29, Lordship.
Mr. Gogoi, you have said because of the problem you are not releasing. I have clarified that. You just pay him now. That's all.
Lordship.
This is his entitled due.
Entitled dues.
And
Lordship.
interest and all
Entitled dues.
thing, we will, basing on your conduct, we will see on the next day.
We should include gratuity. Gratuity, they should have released it immediately.
Anyway, Mr. Bora,
How long?
Lordship.
you make a mention in the morning, 10:30. We will take up the, give you a out of turn hearing, no problem. Friday. Thursday, you make the payments. Order to ite upload koi dibe.
Obliged.
33.
May I please, your lordship?
Yes, madam.
Please, your lordship, this is regarding dismissal from service, lordship. Petitioner was holding the post of Nayak, lordship,
Hmm.
in Assam Police,
Hmm.
associated with CID office, lordship.
Hmm.
Thereafter, he was arrested, lordship, on 28/9/2022, lordship.
Hmm.
Due to some, allegation was there, lordship, against him, FIR was there, under PCX 7A, lordship, section.
Hmm.
He was arrested, lordship, then he was suspended on 1/10/2022, lordship.
Oh.
Thereafter, bail was moved, lordship, on 28/11/22, up to, 22, lordship, bail order, he was released, lordship. Thereafter, lordship, show cause notice was served upon page number 40, lordship.
Hmm.
First show cause notice, lordship.
Hmm.
That is on 1st December 2022, lordship.
Hmm.
May I read, lordship?
No, it's okay.
Lordship,
Go ahead.
In this show cause notice, lordship, the language reflects that their mind was quite predetermined, lordship. They're saying that why the penalties prescribed therein should not be inflicted upon, lordship, major
Okay.
punishment, lordship.
Okay.
Mine was quite predetermined as per my
Okay.
submission, lordship.
Okay. Done.
After I
Accepted. Next.
I filed reply, lordship.
Hmm.
Reply with first show cause, lordship, charges was misconduct and relation duty, lordship. Thereafter, lordship, second show cause notice was served upon lordship 8th February 23, lordship.
Hmm.
Enclosing the inquiry report, departmental inquiry report,
Hmm.
lordship.
Hmm.
Thereafter, lordship, as usual, I was dismissed from service, lordship.
Hmm.
Then I filed an appeal that was also rejected, lordship.
Hmm.
So the petitioner before this honorable court.
Hmm.
With
What is the error?
error, lordship, the allegation,
Hmm.
the Lordship, the inquiry report. Lord. Allegation was that I demanded 10,000 rupees. For actually, Lordship, the Bharti Airtel is the service provider of internet to throughout the Assam police stations, Lordship, and some bills are due, Lordship, and for that respect, Lordship, one Nek Mohammed from their side approached the CID authorities. I mean, for clearance of the
What happened to the criminal case?
criminal case, Lordship, till the charges have not been filed, Lordship. As per my submission is that, Lordship, ultimately only 2,000 rupees was found from his pocket, back pocket, Lordship. He was
Okay, what is the findings of the inquiry officer?
inquiry report, Lordship. Finding page number 50, Lordship. Last para. Lordship, the para prior to this finding facts revealed during inquiry, Lordship. May kindly see, Lordship.
I've seen it, I've seen it.
He admitted in this that that 2,000 rupees for only tea expenses, all this, Lordship. For that reason, Lordship, the major punishment, there are other options also. Some increments may be, I mean, his promotion may be affected, some increment from dismissal from service, Lordship.
Police employee, madam.
Lordship.
Would you like somebody corrupt to protect you?
There, Lordship, but
Then?
he is not an habitual offender, Lordship.
Be that as it may. Come to page 49. These are defense witnesses produced by you.
Lordship.
Page 48.
Yes, Lordship.
Okay. Page 49. 1, 2, 3, 4, 5. Fifth line. When? Right hand side. When he went to.
Inquire about the matter, some people whom he could not recognize asked him to go away and introduce themselves to be police personnel of vigilance and anti-corruption. ABI Ajmal Hussain informed the VN personnel that he had come to treasury for bill-related work from Assam Police Headquarters, and that Nayak UB Miachan Lali, the petitioner, is his assistant. Personnel from so-and-so started their procedure and formalities. Ajmal Hussain was asked to put his signature in the arrest memo, and Nayak so-and-so petitioner, Lordship Ali. Ajmal Hussain stated that he knew Nek Mohammed Ansari but never knew of Miachan Ali making any demand of Nek Mohammed Ansari for deals from Bharti Airtel Limited.
So it is an admitted position that your hands when washed
Yes,
resulted in red color water,
Lordship.
phenolphthalein or something. Now your statement is that you did not know who put 2000.
Yes,
So how did it come in your hand? There is nothing.
Lordship.
Your hand going into your back pocket, finding touching the money, and thereafter
Lordship.
this thing.
What is there in the record, I cannot change, Lordship, but my.
What is the
position-
penalty? Where is the penalty order?
The dismissal order on 56, Lordship, page number 56. I'm just saying, Lordship, for that only 2,000 rupees, Lordship, maybe.
It's not 2000, it's the act.
Yes, Lordship, that misconduct I have understood, Lordship, but there are some other major punishments, Lordship, under major punishment, except dismissal from service, Lordship. He is the sole bread earner of the family, Lordship. Lordship can consider that aspect.
Yes, anything more?
My humble submission before your lordship that before, issuing show cause notice, they have determined, lordship, that they will dismiss me from the service.
Because,
Because
of that statement in paragraph 40, page 40.
and lordship and.
That is only a format, madam. You have
Yes,
done. This is not the first case you are doing. You have done many cases with regard to this.
Lordship.
Huh?
And another.
These are formats. Nothing can be read into it.
My another submission is that, lordship, yes, major punishment, there are some other options, lordship, for major punishment. For first of, he is not an habitual offender, lordship.
What do you have to say on merits with regard to the allegation? Your submission is that you have accepted.
Merits, lordship, he has admitted.
That's the end of the matter. We'll record that. Yes, Mr. Bora.
Your Lordship, the only question which actually becomes the basis for consideration is only in this case is the proportionality of punishment. Here, as has been laid.
That
out
is what
on-
Ms. Konongo is trying to
That's
argue.
what as the law has been laid down, it should be shockingly disproportionate. And that too for a discipline force, Your Lordship, discipline force personnel, police personnel, be it 1 rupee or 2,000 rupees or 2 lakh rupees.
Money
they
is
have-
immaterial.
Money is immaterial, Your Lordship. And he is admitted, Your Lordship. Be it for tea expenses or whatever expenses. Money is money.
Money
It
is money.
Tainted amount, Your Lordship.
On merit, lordship, what is there in inquiry
There's no
report?
ground
What
taken in this whole writ petition as to how it is disproportionate. If your Lordship peruses the
I've
writ
seen it.
petition, it's not, no ground as.
in inquiry report, lordship has seen, he has, deposed, lordship, his stand. That I cannot change. I can say only that
I
can.
got it, Ms. Konongo. Your limitations I can understand with regard to the materials.
It is already there in the material. I cannot deny that, lordship. I can only see what is the disproportionate punishment has given to him, lordship. It is not their case that petitioner is the habitual offender. That is why this is the several times we caught him. So this
So
time.
how many times taking bribe a police person should be caught before?
No, lordship, that is not. I'm not saying like
You are
that.
before a wrong court.
No, lordship. Lordship, kindly consider this aspect.
Well considered.
This disproportionate punishment aspect, lordship, because
We'll consider. Heard Ms. S. Konongo, learned counsel for the petitioner. Also heard Mr. D. Bora, learned government advocate appearing for the respondents. Hearing concluded. Virospati Don't expect much
Lordship.
for delivery of order. Anything further? লেখা। নহলে এইটো ভিতৰতে দি দিম। We'll pass the orders.
Yes.
Anything more?
9,83,976,000 has been deducted from pension amount. 9,83,976,000. 983976.
নামকেইটা লৈ ল'ব চোন। ইয়াত লগাই দিলে। Dispose of. You just return that amount.
Yes.
Lordship, one thing is to be
Within a
considered.
time frame, my lord.
Lordship, if the overstay amount is refund, Lordship, then he will injure both salary as well.
No, his
After deduction.
pension would be, pension has been granted.
Yes, yes. After check calculation, the date of 2021, my lord. That 1 year has been deducted, my lord.
Oh,
That
That
is
has
done,
to
my
be-
lord.
that has to be-
Recovery.
so the pension that you have drawn, what will happen to that?
Lordship,
You have drawn pension from which date? From the date of retirement?
No, from the corrected date, my lord. 21, my lord.
Huh?
They have corrected, my lord.
So now if we,
This is already
no,
done.
no. Now if we ask them to repay you this,
Yes.
Lordship,
okay, whatever pension he has drawn, recover that.
recover. Lordship,
Come to, where is the PPO?
Yes. If you pays 28, my lord.
Okay. When is your date of actual retirement?
Actual, my lord. 1/1/22, my lord.
And you retired?
31/12/22, my lord. That exercise already done, my lord. That exercise already done. Initially proposal was made, my lord. That has been written, my lord. For correcting the same, my lord.
Where is that?
Yes, my lord. That is the, my lord. Yes, my lord. It's in, my lord. Page 19. Page 19, pension.
From which date did you receive pension? Is it from 1/1/22 or 1/1/23?
That is actually.
if
Have
you
that
was
instruction.
authorized from 1/1/22, your Lordship.
Where is that?
Yes, I have the instructions. Yes.
Right. As prayed for by the Learned Council for the parties, list this matter again on Thursday. Full stop. On the next date of listing, the Learned Council for the petitioner shall apprise this court as to the date from which the petitioner had drawn his pension and pensionary benefits.
That one will be deducted.
If you have drawn for that
Yes.
period also,
That will be deducted.
if you have been given from 1/1/2023, we have nothing to say.
Yes.
Then you will get the salaries. Otherwise, salary minus pension.
Yes.
Thursday.
Right.
Only let him get his instruction from which date he is drawing his pension. You have said 1/1/22, but let him also have that instruction. We'll have it on Thursday, we'll finish it up that one. This Thursday. Or should I?
This Thursday, my lord.
Next Thursday.
No, your lordship will not be there, my lord.
Lordship, will you have it? Next Thursday.
Next Thursday, I'll not be here. Item number কি মানে তো?
Let him take it on Thursday.
Thursday, my lord.
Thursday, we have heard it, only order is to be passed. Only thing is that we'll ask you, the deduction, we will say bad. But the pension, if he has drawn on the same period, that much will be deducted.
Yes.
Okay?
Yes. Obliged.
You get your instructions.
My lord.
Or tomorrow. Huh?
Yes.
Tomorrow?
Tomorrow, my lord.
Tomorrow saying.
You can get your instructions.
Yes, my lord.
Kali did you? Huh? By sleep did you?
My lord.
Tomorrow. Kali did you?
Obliged.
Obliged.